Tekrar merhaba. Dünkü oturumlarda dünyada ifade özgürlüğünün karşılaştığı sorunları konuşmuştuk. Bugün Türkiye'yi konuşacağız. Önce durumumuza genel bir bakış.
Anayasa 2. maddesinde Türkiye'nin laik, sosyal bir hukuk devleti olduğunu tanımlıyor. Kazın ayağı belki hiçbir zaman böyle olmadı ama din ve inanç özgürlüğü bağlamında bugünkü kadar sorunlu da olmadı. Neredeyse Cumhuriyet'le yaşıt Diyanet İşleri Başkanlığı kelimenin tam anlamıyla altın çağını yaşıyor. Başkanlığa bütçeden ayrılan pay rekor üstüne rekor kırıyor. Başkanlığın ülkenin bütçesinde sahip olduğu pay birçok bakanlıktan fazla. Hakkını da veriyor vesselam. Televizyon yayınlarından cinsiyet politikalarına, makbul Müslüman tanımından yargı kararına varıncaya kadar iktidarın boğazına sarıldığı tüm özgürlüklere karşı Diyanet İşleri Başkanlığı da siyasi propagandanın önemli bir aracı olarak görevini yerine getiriyor. Ülke nüfusunun önemli bir kesimini oluşturan Alevi, Bektaşi, Kızılbaş topluluklarının inançları, ritüel ve ibadetleri hakim Sünni Müslüman görüş eliyle tanımlanmaya ve yasaklanmaya devam ediyor. Sünni Müslüman öğreti halen ilkokulda zorunlu ders müfredatının parçası. Ateizm, deizm ve diğer inançlar devlet imkanlarını arkasına alan makbul Müslüman öğretinin ekonomik ve düşünsel taciz ve saldırılarının odağında yer alıyor. Her biri Diyanet ve iktidar tarafından milli güvenlik sorunu olarak görülüyor. Gayrimüslim azınlık cemaatlerinin iç işleri, seçimleri ve malları halen iktidar eliyle şekillendirilmeye çalışılıyor. Klasik Sünni Müslüman öğretiler aleminin bir parçası olmanız da sizi tek başına makbul yapmıyor. Siyasal iktidarla bir nedenle yolların ters düştüyse inanç önderleriniz tutuklanıyor, eylem ve ibadetleriniz engelleniyor, en acımasız kolluk şiddetiyle muhatap olabiliyorsunuz. Türkiye laik, sosyal bir hukuk devleti, öyle mi?
Bizim şu anda gerçekleştirmeye çalıştığımız mücadele Alparslan Kuytul Hoca Efendi'ye özgürlük davasından ya da 8 tutuklu kardeşimize özgürlük davasından öte bir noktaya taşındı. Biz haksızlığa uğradığımızı dile getirme mücadelesi veriyoruz. İfade özgürlüğü mücadelesi veriyoruz. Anayasal haklarımızı kullanabilmenin mücadelesini veriyoruz. Yani insanlar konvoy yapıyorlar ve normal karşılanıyor. Dün gece de buradan bir konvoy geçti ve tüm emniyet burada olduğu halde izlediler. Ki zaten bir sakıncası yok. Ben diğer konvoylarda engellensin demiyorum zaten. Ama biz bir karşılama, bir uğurlama gibi bir konvoy, küçük bir konvoy 4-5 araba yapmaya kalktığımızda hemen arabaların plakaları alınıyor ve çok ilginç gerekçelerle ceza geliyor. Mesela işte yakın takip yapmış diyerek ya da bu da ilginç. Güvenlik şubenin referansıyla yazıyor, yani ceza kağıdında böyle yazıyor. Beni karşılamaya gelmişti arkadaşlar, evimizin önüne park halinde olan araçların plakaları çekilip ceza geldi. Çok yönlü bir abluka altındayız. Yani bir yönüyle zulme uğruyoruz, bir yönüyle de zulme uğradığımızın duyulmasını, bunu duyurmamızı engellemek için de baskıya uğruyoruz. Biz anayasal hakkımızı kullanmak istiyoruz. Bize protesto hakkımızın verilmesini istiyoruz. Sadece Adana'da değil, tüm Türkiye'de protesto hakkımızın bize tekrar verilmesini, meşru düzlemde bunu yapabilmeyi istiyoruz. İstesek biz Adana'nın başka caddelerinde, başka ilçelerinde büyük yürüyüşler gerçekleştirebiliriz. Polis her yerde böyle burada beklediği gibi hazır bir şekilde beklemiyor. Yetişemeyebilirler ki çok yaptık bunun gibi. Ama böyle yapmak istemiyoruz. Yani ne zamana kadar kaça kendi hakkımı kaça mı kullanacağım? Yani bize yasaların tanıdığı hakkı aman bizi görmesinler, suç işliyormuş gibi gizli mi yapacağız? Ne zamana kadar böyle yapacağız? Bunun böyle devam etmesini istemediğimiz için geldik meydana, oturduk. Bize yasal hakkımızı ya verirsiniz ya da biz buradan gitmeyiz diyoruz. Bizim arkadaşlarımız eylem yapıyor. Oradan geçen bir vatandaş neden bu adamlara böyle zulmediyorsunuz dediği için polis tarafından işkence tarzında bir dayağa tabi tutuluyor. Hani adam kendini ifade etti. O bir vatandaş kendini ifade etti. Bunun için insan dövülür mü? Yani böyle bir baskı var. Esnaflara soruyorsunuz sıkıntınız var mı? Adamlar hayat pahalı demeye korkuyor. Yani şimdi böyle bir baskının olduğu bir memlekette huzur olmaz. Böyle bir diktatörlüğün hakim olduğu bir memlekette ezilmiş insanlar olur ki zaten şu anda nesil öyle olmaya doğru gidiyor. Biraz özgürlüğüne düşkün olup biraz işte yani bu ezilmeyi kabul etmeyenler yurt dışına çıkmayı çare olarak görüyor. Ya biz yurt dışına çıkmaktansa, neslimizin yurt dışına kaçmaya çalışmasındansa onlara memleketlerinde bir özgürlük alanı oluşturmak için mücadele ediyoruz. Yaptığımızın böyle bir tarafı da var.
Yeni değil. Cumhuriyet tarihi boyunca cezasızlığın Türkiye'de de hatırı sayılır bir geçmişi var. Herkesin gözü önünde. Ama devletin yüce çıkarları için işlenen birçok suç cezasızlık zırhı altında işlenebildi. Daha 1955'te İstanbul'daki tüm azınlıklara karşı uygulanan pogrom olayını başlatan bombayı atan MİT ajanı cezalandırılacağına ödüllendirildi. Valiliğe kadar yükseldi. Cezasızlık yaygın bir sistematik devlet pratiği olarak Türkiye'de de varlığını sürdürüyor. Adliyelerden yükselen adalet çığlıkları karşılıksız kaldı. Erdoğan Berfana'ya verdiği sözü tutmadı. İşkence dosyalarının akıbeti yine takipsizlik oldu. Roboski'ye adalet 10 yıldır gelmedi. Öte yandan polisin fail olduğu suçlarda deliller karartıldı. Polisin sanık olduğu davalara ihsas rey yasağını delen atamalar yapıldı. İHA'nın verilerine göre 2008'den bu yana 20'si çocuk, 42 sivil zırhlı kolluk araçlarının altında can verdi. Baran Tursun Vakfı'nın verilerine göre de yapılan kanun değişikliğiyle polisin silah kullanma yetkisinin genişletilmesinin üzerinden geçen 14 yılda polislerin kullandığı orantısız güç sonucu 413 kişi yaşamını yitirdi. Uzatılan soruşturma ve yargılama süreçleri suçluları adaletin önünden kaçırmanın en etkili yollarından oldu. 14 yıl süren Hrant Dink cinayeti davasında sorumluluğu olan kamu görevlilerinden hiçbiri yargıya hesap vermedi. Tahir Elçi'nin katledilmesine dair devam eden yargılamada aynı akıbetle karşı karşıya. 90'lı yıllarda kaybetmelerin ve toplum katliamlarının odağı haline gelen faili JITEM olan yargılamaların bir kısmı zaman aşımına uğradı, geri kalanında aynı akıbetle karşı karşıya. Faili devletin kolluk görevlileri ya da bürokratları olan taciz, tecavüz, istismar davaları etkin şekilde soruşturulmuyor, failler ilk fırsatta aramıza salınıveriyor. Türkiye toplumu artık adaleti mahkeme salonlarında değil, adliye binalarının önünde arıyor.
...14 Haziran 2018 tarihinde iş yerimize bir saldırı oluyor. Bu saldırı Suruç Devlet Hastanesi'nde bir katliama dönüşüyor. İş yerimize AKP'nin bir milletvekili ve ailesi saldırıyor. İş yerimizde 5 kardeş olarak hepimizi ağır bir şekilde yaralanıyorlar. Yaralı olarak ambulanslarla bizi Suruç Devlet Hastanesi'ne kaldırıyorlar. Olayı duyan babam da Suruç Devlet Hastanesi'ne geliyor. Suruç Devlet Hastanesi'nin içinde babamı ve 2 kardeşimi ateşli silahlarla linç ederek katlediyorlar. Bu katliam güvenlik kameralarının önünde yapılmıştır. Hastanedeki bu katliam sağlık çalışanlarının gözünde yapılmıştır. Hastanedeki bu katliam yüzlerce kolluk kuvvetinin gözünde yapılmıştır. Hastane katliamında milletvekili orada olduğu için kolluk kuvvetine müdahale etmeyin, bunlar teröristtir, biz bunların hepsini öldüreceğiz demiş ve kolluk kuvveti de görevini yapmamıştır. Hastanede bu infaz, bu katliam yapılıyor. Dava üzerinden 4 yıldır süre geçiyor. Hastane katliam davasıyla ilgili hala gizlilik kararı devam ediyor. Bundan dolayı biz adliye önünde annemle beraber bir nöbete başladık. Nöbetimiz bugün 443. günde devam ediyor. İş yerimizde yaptığımız bütün eylemler meşru müdafaa kapsamında olmasına rağmen sırf katliamı yapan İktidar Partisi'nin milletvekili olduğu için bir kardeşimiz de 4 yıldır hukuksuz bir şekilde tek kişilik hücrede tutuklu bulunuyor. Tüm bu hukuksuzluklara ve adaletsizliğe karşı annemle beraber adliye önünde bir nöbete başladık. Nöbetimiz bir yeri geride bıraktı. Biz adalet istiyoruz. Bu olayı artık bütün Türkiye biliyor. Türkiye'nin gündemindedir. Türkiye Büyük Millet Meclisi'nin gündemindedir. Katliam yapan İktidar Partisi'nin milletvekili olduğu için mecliste gündeme geldiğinde bütün milletvekilleri sessiz, yani sağır kör oluyorlar. Yargıyla ilgili, davamızla ilgili savcıyla görüşmek istediğimizde savcılar bizden kaçıyor. Davamızla ilgili 9 dosya savcısı değişti. En son davamızla ilgili, mücadelemizle ilgili nöbetimiz 4 yıla girerken olay üzerinden 4 yıl geçecekken hastane katliamıyla ilgili içinde milletvekilinin abisinde olduğu 4 kişi tutuklanmıştır. Ama dava üzerinde hala gizlilik kararı devam ediyor. Bu katliam organizedir. Hastane kamera kayıtları, savcı yok diyor, devlet yetkileri var diyor. Biz bu hukuksuzluğu, bu adaletsizliği bir an önce giderilmesini istiyoruz. Bu adalet gelene kadar da annemle beraber mücadelemize adliye önünde devam edeceğiz.
Anayasanın 34. maddesinde güvence altında bulunan toplantı ve gösteri hakkı iktidar tarafından rafa kaldırılmış durumda. Her ne kadar anayasa ve kanunlarda izne ve başkaca bir onaya tabi olmayan bir hak olarak tanınsa da aynı kanunlarda düzenlenen milli güvenlik, kamu güvenliği, genel ahlak gibi muğlak ve ne anlama geldiği belli olmayan kısıtlamalar sebebiyle bu hak idare eliyle kullanılamaz hale getirilmiş durumda. Adalet Bakanlığı istatistiklerine göre toplantı ve gösteri yürüyüşleri kanununa muhalefet iddiasıyla 7 yılda açılan 63 binden fazla davada 12 bine yakın yurttaş mahkum oldu. 9.400'den fazla yurttaş hakkında da hükmün açıklanması geri bırakıldı. Toplantı ve gösteri hakkı, valilikler tarafından değişen sürelerle ilan edilen yasaklama kararlarıyla bazı kentlerde aylardır, bazı kentlerde ise yıllardır kullanılamaz hale getirilmiş durumdayken, mülki idareler artık adrese teslim yasaklar bile ilan ediyor. Anayasal güvence altındaki bir hakkın kullanımının idare eliyle engellenmesi öyle boyutlara vardı ki, Van'da eylemler kesintisiz olarak 5 yıldır yasak. Muhalefet partileri, sendikalar, meslek örgütleri, salgının en ön safında mücadele eden sağlık çalışanları, haklarını arayan işçiler, kadın cinayetlerine dur diyen kadınlar, demokratik üniversite talep eden öğrenciler, kısacası toplumun her kesiminden yurttaşlar yasaklarla ve kolluk şiddetiyle karşılaşıyorlar. Hülasası toplantı ve gösteri hakkı fiilen yasak, kolluk şiddeti ise kural.
Van'da 15 Temmuz darbe girişiminden sonra fiili bir OHA süreci devam etmektedir. 5,5 yılı aşkın süredir Anayasa ve Avrupa İnsan Hakları Sözleşmesi ile güvence altına alınmış olan toplantı ve gösteri yürüyüşü hakkı ile bu hakka sıkıya bağlı olan ifade özgürlüğü hakkı valiliğin yasaklama kararlarıyla ihlal edilmektedir. Van Valiliği tarafından kesintisiz olarak yasaklama kararları alınmaya devam etmekte. Nitekim en son 13 Mayıs 2022 tarihinde yine 15 günlük yasaklama kararı alınmıştır. Bu yasaklama kararlarının bir kısmını Van Barosu olarak yargıya taşıdık. Ancak idari yargı tarafından anayasaya ve kanuna aykırı gerekçelerle davalar reddedilmiştir. Bu davaların bir kısmı halen istinaf incelemesindedir. Güvenlikçi politikalarla hakkın sınırlanması anayasaya ve ölçülük ilkesine açıkça ve tartışmasız bir şekilde aykırıdır. Mevcut mevzuata dahi uyulmamakta, uluslararası sözleşmeler ve anayasa ihlal edilmektedir. Anayasa, herkesin önceden izin almaksızın toplantı ve gösteri yürüyüşü yapabileceğini hüküm altına almıştır. Ancak valiliğin yasaklama kararlarına gerekçe olarak gösterdiği 2911 sayılı yasanın 17. maddesiyle 5442 sayılı yasanın 11. maddesi somut duruma göre sadece belirli bir toplantının yasaklanabileceğini ifade etmektedir. Yasalar valiliklere kamu düzeni ve kamu güvenliği açısından belirli bir toplantıyı, bakın özellikle ifade ediyorum, yalnızca belirli bir toplantıyı yasaklama yetkisi vermekteyken Van Valiliği henüz var olmamış, henüz planlanmamış, henüz tasarlanmamış bir toplantıyı, bir basın açıklamasını, bir gösteri yürüyüşünü dahi yasaklayabilmektedir. Bu husus yasal olmadığı gibi suç teşkil etmektedir. Halkın anayasal haklarını fiilen ve kanuni olmayan kararlarla yasaklanması, askıya alınması asla ve asla kabul edilemez. Demokratik düzenlerde özgürlükler asıl, yasaklar istisnadır. Ancak Van'da durum tam tersidir. Yasaklar asıl, özgürlükler istisna olmuştur. Anayasal hakların kısıtlanmasını, hakkın kullanılmasının sınırlanmasını yasaklayan söz konusu hukuksuz idari kararlara derhal son verilmelidir.
Türkiye'de sanatsal ifade özgürlüğünün her ne kadar anayasal güvence altında olduğu kabul edilse de gerçekler bize tamamen farklı bir fotoğraf sunuyor. Öyle ki anayasanın devlet sanat faaliyetlerini ve sanatçıyı korur diyen 64. maddesini hatırlatan sanatçıya bile soruşturma açılabildiği bir ülkede yaşıyoruz. Türkiye, sanatsal ifade özgürlüğünün en çok ihlal edildiği, sanatçıların yargılandığı, gözaltına alındığı, hapis cezasına çarptırıldığı ve sansürlendiği ülkeler arasında ön sıralarda. Sansürün ve sanatsal ifade özgürlüğüne yönelik ihlallerin gerekçeleri ise çoğunlukla terör, propaganda, hakaret, genel ahlak, müstehcenlik ve kamu düzeni olarak kayıtlara geçiyor. Sanatsal ifade özgürlüğü ihlallerinin %90'ından fazlasında sorumlu olan hükümet yetkilileri, ülkede sanatsal özgürlüklerin kullanılmasının önündeki en büyük engel. Müzisyenlere propaganda ve Cumhurbaşkanı'na hakaret kapsamında davalar açılıyor. Birçok sanatçı ve etkinlik, milli güvenlik ve kamu düzeninin korunması gibi gerekçelerle kriminalize ediliyor, yasaklanıyor. Toplatma, dağıtımı engelleme kararlarıyla birlikte yazar ve yayın evlerinin yargılandıkları davalar hiç eksik olmuyor. Kitaplar, soruşturmalar ve davalarda delil olarak kullanılıyor, toplatılıyor ve yayın evleri kapatılıyor. Küçükleri Muzdır Neşriyat'tan Koruma Kurulu, iktidarın yayınlama özgürlüğü karşısında yeni sansür araçlarından birisi. Öte yandan sansür ve yasaklamaların artık yurttaşlar tarafından da doğal karşılanması, hatta desteklenmesi çok dikkat çekici bir gelişme olarak karşımızda duruyor. Sosyal medya üzerinden hedef alınan yayın evleri bazı kitapları yayından kaldırırken haklarında dava açılan yazarlar, yayıncılar oldu. Tüm bu baskı atmosferi ise yazar ve yayıncılara otosansüre yönlendirmeye devam ediyor.
Ee, 2015 Nujin filmini, yani ben Komane'den döndükten sonra Nujin filmini çektim ve İstanbul'da ve çeşitli yerlerde filmi gösterdik. Sonra 2015'in sonlarına doğru Batman'da da filmi gösterdik. Batman'da afiş asım sürecinde afişleri toplatıldı. Filmin. O dönem Dicle Anter'de sinemanın yöneticisiydi. Afiş toplatıldı ama biz filmi gösterdik o dönem ve herhangi bir sorun çıkmamıştı. Bir süre sonra emniyetten aradılar ve yanılmıyorsam 2-3 aylık bir süre sonra emniyetten aradılar ve filmle ilgili ifade vermem gerektiğini söylediler. Ben de Batman'a gideceğimi, Batman'a gittiğimde ifade vereceğimi söyledim. Bir ara Batman'a gittim. Böyle bir davanın olmadığı, böyle bir kim tarafından arandım bilmiyoruz ama herhangi bir soruşturma, herhangi bir ifade yok denildi o zaman savcılıkta. Ve ben geri döndüm. Yaklaşık bir sene sonra dava açıldığını öğrendim tekrar. Ben ve Dicle Anter'e filmle ilgili dava açıldı. Dava yaklaşık 2 sene sürdü. 2 sene sonunda Dicle Anter'in hiçbir alakasının olmamasına rağmen Dicle Anter'e 2 yıl 1 ay, bana da 2,5 yıl ceza verdiler filmden dolayı. Ve yurt dışı yasağı kondu. Yurt dışı yasağı konunca ben yurt dışındaydım zaten. Ceza aldığım zaman da yurt dışındaydım. Bir festivale gitmiştim. Yurt dışı yasam olmasına rağmen geri döndüm. Yaklaşık 3 yıl yurt dışı yasağım devam etti. Dicle Anter İsveç vatandaşı olmasına rağmen cezası devam etti. Her duruşmada hakime şunu söyledik. Yani ben zaten yurt dışındayım. Bu ülkeyi terk etseydim, gelmeseydim, yani kaçma şüphe olsa zaten geri dönmezdim. Israr etmemize rağmen yaklaşık 3 yıl yurt dışı yasam sürdü. O dönem yeni bir film çekmiştim, Kuyu adında. O dönem filmim uluslararası film festivallerine katılıyordu. Hiçbir tanesine katılamadım. Hiçbir tanesine gidemedim. Bunu ısrarla söylemiş olmamıza rağmen. Hatta Dicle Anter'in çocuğunun düğünü oldu. İsveç'te çocukları yaşıyordu. Bunlar delilli bir şekilde sunuldu. Ona rağmen bize 3 yıl boyunca hiçbir şekilde yurt dışı yasamızı kaldırmadılar. Ve 3 yılın sonunda biz istinafa, zaten o arada istinaf mahkemesine götürdük mahkemeyi. İstinaf usulden kararı bozdu, geri gönderdi. Geri gönderdikten sonraki yargılama sürecinde benim cezam 1 yıl 15 güne indirildi. Yurt dışı yasam kalktı. Dicle Anter'in de 10 ay 15 güne indirildi ve para cezasına çevrildi. Yurt dışı yasamız öyle kaldırıldı ama biz bir üst mahkeme tekrar götürdük. İstinafa tekrar götürdük bunu. Çünkü iddia edilen şeylerin filmle alakası yok. Ceza verdikleri şeyin filmle, afişle alakası yok. Bahsettikleri şeyin bir belirginliği yok. Tamamıyla üstten körü, kes, yapıştırla hazırlanmış bir iddianame. Hatta hakimin ve hatta savcının da neye ceza verdiklerine dair bir fikirleri yoktu yani. Filmi izlememişlerdi. Belliydi. Hatta afişi bulamamışlardı. Afişi biz istinafa gönderdikten sonra, afiş istinaf şeyi bozduktan sonra, yani öyle bir internette bir afiş bulmuşlar. Dosyaya koymuşlar. Zaten istinaf da ondan bozmuştu. Yani bir belirginlik yok. Bu afiş neye hitap ettik, hangi filme ait olduğuna dair bir şey yok. Buna nasıl ceza vermişsiniz diye bozmuştu. Afişi bile bulamamışlardı. Afişi bile yani ceza verdikleri afiş bile dosyada yoktu. Ona rağmen bize ceza verdiler ve 3 yıl yurt dışı yasağına çıkamadık. Yurt dışına çıkamadık. Kendi işimizi... Çünkü benim zaten çektiğim filmler, katıldığım festivallerden dolayı işimin büyük bir kısmı yurt dışında olmasına rağmen ekstra bir cezalandırma yöntemiyle yurt dışı yasağı koydular ve dava hala bozulduktan sonra istinafa götürdük. Hala istinafta, sonuç ne çıkar bilmiyoruz açıkçası.
Merhaba. Bugün
Hello, everyone. Today, we are on the second day of the Istanbul gathering for the freedom of expression. Together with our participants, we will be having a panel session now. Yesterday, there was a panel that was the first one. Today we have the second and the third. We have the human rights organizations of Turkey, the prominent ones among us, and also representatives from other organizations. We have 8 speakers. The title is Freedom of Expression in Turkey. The second panel is different. So we will be talking about the freedom of expression. If you look into this, and there are some people who have studied this topic. Professor Bülent Tanür really did his PhD on this question in 1968 and 69, and he's now long gone. Said Duran also touched upon this, and he wrote his dissertation, PhD dissertation, on the administrative intervention in the freedom of expression in 1969. So we have very valuable researchers in this area. Turkey, of course, developed over a period, changed its legislation on this issue, and after Articles 141, 142, and 163, which banned certain currents of opinion, were rescinded, Bülent Tanür, I remember talking to him. He said he was going for a new edition, but then there was the anti-terrorist law, which was, Bülent Tanür said, like a constitution. So I am going to, he said, rewrite the book and take up this question very profoundly. Today also we have a lot of problems regarding freedom of expression in Turkey in its different versions. Political expression, artistic expression, media freedoms, alternative media outlets. So this is a kind of set of phenomena which has many facets. I would like to start with a request from the speakers. Would the other speakers mute their mic while one of the speakers is talking? Let's start with the Human Rights Association. Öztürk Türkdoğan, who is the president of the association, is among us. Well, for the moment, we have only 5 minutes for each speaker. We could increase this when there are questions in the second and third rounds. Thank you. I greet everyone with affection and respect. I would like to take up where you left off, Professor Tarhanlı. When the anti-terror law was passed in 1991, in particular, the Contemporary Jurists Association called this an iron cage. This was really an iron cage in which was put the group of human rights defenders. In the last 6 years, more than 1,700,000 people were investigated for terror. And for around 350,000 to 400,000 people were prosecuted for for propaganda for the terrorist organization. So in such a country, this accusation is leveled at everyone almost. And this, of course, threatens the freedom of expression, obviously. Another point, of course, problems that arise from other kinds of legislation. For instance, the 399, Article 399 of the Penal Code, which is insult to the president. There were other articles such as 321 and others. But the European Court of Human Rights demanded that this article be rescinded, that is to say, insult to the president. There are so many cases of the European Court of Human Rights that act as jurisprudence with respect to this article, but nothing is being done. In times of democratization, we see that the number of cases go down. But in the last 7 years, as the regime is becoming more and more authoritarian, even bordering on autocracy, and we see then the numbers have multiplied. And since the freedom of expression is the basis of democracy, it is very difficult to say that we have a full-scale democracy. You cannot organize, you cannot, your right of association, the freedom of association is trampled upon, the freedom of assembly, etc., are all contingent on this. But nonetheless, social opposition in Turkey is very active. Many people are in prison because of their crimes of opinion. As you know, two findings of the European Court of Human Rights, Osman Kavala and Selahattin Demirtas cases, legally, there are two people who have the status of political prisoner in Turkey. This has been really recorded by the higher court decision. And the government is continuing its repressive attitude. We are all prosecuted for different kinds of crimes, supposed crimes, but we are also continuing our struggle for the freedom of expression. There are so many things to be said, but let me add that this is not peculiar to this moment in time. Of course, in this period, it's the number of cases, etc., are higher. But then, since Turkey was founded, there were the repressive measures taken against freedom of expression. The source of the articles 141, 142, 163 that I mentioned before is the penal code of Italian fascism. Italy then changed it and inserted violence as a precondition there, but not Turkey. And of course, this really shows the character of the regime. One has to emphasize this. Within this period, we constantly talk about how this is tied to democratization. Within the harmonization process for the European Union, certain steps were taken, but then there was no continuation of this move forward. And the Human Rights Action Plan and the Judiciary Strategy Plan declared by the government and sent to Parliament has 6 different draft laws in the package. There are certain steps taken forward, but 2 steps are taken back in other articles. A draft law is now on the agenda, which really totally represses the rights of those people who use the social media. Well, the news that the government does not want to be propagated, such as inflation figures, etc., are targeted here. And this really goes beyond the freedom of expression. This is a new situation which has to do with the repressive character of the regime. Now, this is not a matter of changing the legislation on the freedom of expression. It is really a question of changing the regime. We need to change the regime. Of course, here the struggle of the political and social opposition can, of course, really bring us a new regime that is a solution. Well, you did draw a very important framework for our beginning, while imparting to us your experience and your observations. When we look at at Article 1 of the Turkish Criminal Code, and the defenders of human rights know this, there are certain values referred to as the objective of the criminal code. And the first one there is the defense of the freedoms and rights of the individual. Of course, the others will be taken into consideration, but if this is number 1 in the criminal code, in the implementation of all the provisions of this criminal code, one needs to demand the implementation of this provision as well. This is not fantastic. It is simply the spirit of that law. Thank you very much, Öztürk Türkdoğan. Now, a second important organization for human rights in Turkey is the Human Rights Foundation of Turkey, and I would like to turn the floor over to Coşkun Üsterci. Thank you, Professor Tarhanlı. I would like to greet everyone. I thank Öztürk, which was a very good framework to begin with. Well, we are many organizations here who fight for human rights. We probably will say similar things. What should I emphasize? I thought to myself. And I wanted to talk about a concrete case of freedom of expression. And to the extent that the time limit gives me the possibility, I will talk about this. After the failed coup of 2016, we all know that the representatives of central government in the provinces and the districts of Turkey resort to general bans on the freedom of assembly. Of course, this really eliminates the essence of the right. But first of all, let me touch upon certain theoretical aspects of the question. The European Court of Human Rights has its jurisprudence on this question. The freedom of assembly and the freedom of expression are taken up together, and these are indissociable. In particular, the freedom of association is really an expression, a manifestation of the freedom of expression. If you have the freedom of expression, then we can talk about democracy. Otherwise, no. And the Constitutional Court of Turkey has certain decisions. For instance, in one of these, the Constitutional Court says the freedom of assembly is taken under a guarantee in Article 34. for this to be implemented in a peaceful manner, and this should be interpreted as the protection of the right to of assembly in a pacific manner. The political ideas that are defended on a peaceful basis should be able to express themselves in demonstrations and marches. Each limitation on the freedom of assembly also removes and eliminates the freedom of expression. Now, coming back to the representatives of the central government in provinces and districts, they rely on two different laws. The second one is the law on demonstrations and marches, which is law number 2911. Sometimes these authorities limit this right to a very great extent. Sometimes they remove totally the possibility of organizing demonstrations and ban them. The administrative authorities follow on the steps of each other in order to provide a permanence for this. Well, of the two laws, one says a ban of 15 days is possible, but the other says a ban of 30 days is possible. However, the administrative authorities, local administrative authorities, bring these prohibitions one after the other, so that the whole thing results in a situation where no one can organize a demonstration or a march for months on end or years on end. Now, in 2021, in 26 provinces, more than 44 million citizens were subjected to a ban on demonstrations for at least 1 day and up to 30 days. So they were not able to use their freedom of assembly. In 2020, the first 5 months of 2022, this was again very widespread. Well, this is a cut and paste kind of, reason given for these. Well, setting up tents and setting up stands, distributing leaflets, or putting up posters on the buildings of political parties or in other places is banned together with this. The most striking example comes in Van, an eastern province of Turkey. Since 2016, since 21st November 2016, the provincial governor's office has been making these decisions one right after the other, and all activities have been banned. As a result, we are face to face with a very serious, grave question. As we all know, the freedoms of expression, assembly, and association are rights that can be limited, but then you have to pay attention to several very important things. First of all, the enjoyment of these freedoms should be interpreted in the broadest manner possible. But the fundamental precondition is not to touch the essence of the right. In VAN, our foundation, we have a representative in VAN, and we have a doctor there, a medical doctor. We shot a video in order to show the absurdity of the situation. A small child, a baby is born on the 21st of November 2016, the first day of the prohibition. She's now 5 years and 6 months old, but there is a continuing prohibition on her freedom of expression. So this really touches the essence of the right. This is not a proportional limitation or restriction. This is really the abolition of the right, full abolition of the right. And this shows where the country has come from the point of view of the freedom of assembly and from the point of the use of enjoyment of democratic rights. I just wanted to underline this implementation, and I think my time is over, and perhaps we can also talk about these examples further on.
Thank you so much. You are very right, actually. Freedom of expression is actually beyond certain things. It's about coming together peacefully, freedom of assembly, freedom of organization, political organization. So freedom of expression encompasses all these areas. That is why that aspect of the freedom of expression is very important, and you have shared some figures with us, and you're pointing out to a very important thing. We have some freedoms that can be restricted and that cannot be restricted. For instance, ban on torture cannot be restricted. It's the field of rights. Freedom of assembly and association might be subject to certain restrictions, but as you said, it's very important to be proportional. It's important to make sure that legality is there. We need to have the legal framework in line with democratic rules and principles, but sometimes we see some very problematic cases, as you have shared with us. Thank you. So, ladies and gentlemen, distinguished participants, let's continue with our third speaker, who is the General President of MAZLUMDER, Kaya Kartal, from the Association for Human Rights and Solidarity for the Oppressed. Thank you, Professor. I would like to thank the previous speakers as well, because as mentioned by Mr. Coşkun, these are the topics that more or less all speakers here will be talking about, because we have been working on these topics based on complaints we receive sometimes. And freedom of assembly and demonstrations is one of the most important freedoms in terms of our field of activity. We have a report activity going on. We're working on the bans that we see in different provinces such as Van or Mardin. Sometimes this right for association and demonstrations are being banned, and freedom of expression is restricted. I don't want to repeat, but I also would like to talk about the right to a fair trial. That's why I would like to talk about the trials regarding anti-terror law. Within the framework of the anti-terror law, most of the trials are actually used as an instrument to oppress the dissidents. This has been the case for long years in Turkey, but this is now more widespread. Professor Tarhanlı talked about Article 1 of the Turkish Penal Code, which aims to protect the rights and freedoms of individuals. But as we see in practice, it is functioning in the right opposite direction. It is now used as a tool to intimidate and oppress or suppress people. When we look at the laws, we see that during the EU harmonization process, we went through certain reform processes. But the dilemma we have is that after each and every reform initiative, the judiciary and the law enforcement officers somehow find their way to punish people even in a more severe way. Well, we are seeing this in the most recent trials. 4 Hizb ut-Tahrir members were actually punished, and the Court of Appeals endorsed the decision. Now we are waiting for the final appeal process, despite the decisions of Constitutional Court. So it's important to look at the Turkish Penal Code, because Hizb ut-Tahrir has been an organization that has been under trial in Turkey for long years, but they were never involved in violence, and within the framework of the old laws, they are considered as unarmed organization. That's why they used to be granted less severe punishments. But after the amendment of the anti-terror law, use of force was redefined, and unarmed terrorist organization, they said they cannot be considered as such, so the law was amended, and the expectation was that we can no longer get sentences based on grounds of being a terrorist organization. However, the Court of Cassation says that although they are not currently using violence, although they are saying that they are not a terrorist organization and not using arms and weapons, but they have certain demands which can happen only through violence and guns. So this is totally incomprehensible. So after 2005, this structure has been defined as a terrorist organization, and that being the case, they are subject to imprisonment starting from 6 years and 3 months. We have seen this in the human rights initiatives as well. We are seeing certain initiatives that can be considered as reform, quote unquote. However, we have so many different articles in the Turkish Penal Code that are now made functional and that are being used of, and more severely than in the past, people are now being punished. So because of this dilemma, what should we do? We have to think about what we can do, because after each reform package announced by the Ministry of Justice, I feel concerned. I think about what is going to happen next, what kind of a sideway the judiciary will find so that these discourses and activities will be considered within the framework of freedom of expression. So we are always concerned about this. Then we have so many cases regarding insulting the president, and we have the crimes committed against Atatürk. So on dissidents, we have so many laws and articles of law that are creating a lot of oppression. For instance, the crime of insulting the president is a very hot topic on the agenda. Even statements that cannot be considered as insult, just criticisms or severe criticisms, are considered as crimes. Again, it's the same thing for crimes committed against Atatürk. For instance, any criticism posed at Kemalist people or who are supporters of Atatürk, not Atatürk himself directly, but this is also considered as a breach of law. So how can we overcome these problems? Of course, through struggle. We need to fight against this. That's what we say. But unfortunately, at this point in time, struggling methods have also been damaged through the Turkish Penal Code, as I have said. Mr. Kaya, thank you so much. I think you completed your speech. What you referred to has been, unfortunately, a problem in Turkey for a long time, not only in the last 20 or 30 years, but even before that. This was a structural way of acting on the government side. As you mentioned, after a reform, although the expectations would be that there would be a reform when we look at the law in practice or the legislation in practice through the use of some other mechanisms that are available within the legislation. It's like going back to square number one and to the previous behavior of the state. That's the policy pursued here. Maybe you would remember one of the former ministers of justice, when we were talking about the amendment of Article 301, he personally said that yes, we are amending law Article 301, but we also have other articles in the Turkish Penal Code. It's not like that our instruments and tools and ammunition has been weakened. No, we still have the power. If necessary, we can make use of those instruments and powers, he said in a nutshell. So that's the type of mentality that they are having. And in terms of democratic emphasis, in terms of the real characteristics of the reform packages, in terms of human rights, putting all these values into life is very important. And thank you so much for your remarks. Now with that, I'll give the floor to the Secretary General of Initiative of Rights Association, Fatma Bostan. The floor is yours. Hello. Well, normally, we always talk about Journalists Without Borders indexes in meetings like this about freedom of expression. So it makes a link between the different countries and the situation compared to past. Turkey has increased by 4 points, ranking 149th this year. And this is not a good thing, as we are actually active in the field of civil society. We have at least been able to rank 149 out of 153, the previous one, but we used to rank 93rd in 2003. So we have really seen a very important degradation in terms of our place in the index. Again, the same association in terms of media ownership has certain data. 90% of the media in Turkey is under the control of the government. Yesterday, our colleague from Hungary said 50% is the percentage in Hungary. So imagine Hungary is subject to a lot of criticism in that area in terms of freedom of expression, but compared to Hungary, Turkey is even in a worse situation. So this is really showing this. And only 10% of the media is free, that can raise the voice of the dissidents. So social media is very important. As mentioned by Mr. Öztürk, the new legislation on social media is very important from that aspect too. So this new law will be discussed by the parliament, the social media law. When you look at the statements they are making, they say the aim of the law is to prevent disinformation, but it's important to have an independent authority to prevent disinformation, or press cards. The institution that will issue the press cards, how will it be structured? This is going to be important. According to the current legislation, an appointed person is in charge of this, and he or she will be appointing another person to be in charge of this for the cancellation or the issuance of the press card. So it will be under the authority of the government. So for us, the duty of the human rights associations is to have advocacy efforts to make sure that there will be an independent authority to issue the press cards. Of course, when we talk about freedom of expression, one of the most important things is what happens during the association and assemblies. We had a circular of the TNP and the Turkish National Police, and the legislation such as a circular is now prevailing over the constitution, the highest legislation that a country can have. So an article of a regulation that foresees a disciplinary sanction against an individual is now seen as prevailing the articles of the constitution. For instance, audio visually recording the demonstrations was regulated while in practice, we were already seeing a ban on people recording or journalists recording the demonstrations. The cameras of journalists were being taken away from them within the framework of the circulation. So another topic we should discuss should be the circular of the Turkish National Police. As we know, sometimes a simple circular can have the power of the constitution in Turkey. Again, another example from Osmaniye, a journalist was threatened, and now this journalist says he's no longer going to practice his profession because of the threats he's receiving. So this is also showing how the situation is bad concerning the media. Again, Freedom House is another important institution making listings for freedom of media freedom. It's 1/4 for Turkey, and for religious freedoms, it's 2/4 on a scale of 4. So, of course, the positive actions that we're taking should also be made visible. Maybe as a positive example, we can talk about the following. For a long time, we had a ban on wearing the headscarf in Turkey. Many women in Turkey wanted to wear the scarf, but they were not able to participate in public and social life because of the headscarf. So now it's possible. So maybe we can talk about this because we receive a lot of criticism about this. And then about other religious and faith-related freedoms, the Alevites have their own worship places, and they still don't have any legal status. So this is a very important shortcoming, especially although there is a court decision about this, still not put into practice. And I'm sorry if I have exceeded my time. Thank you so much, Fatma. You have talked about important issues. The hierarchy of norms has been an important thing that we have been discussing in the legal area, that we always talk about this. Within the hierarchy of norms, of course, circulars do not have the same power as the constitution, but in Turkey, we see that the public is being governed through circulars, and that's how they are approaching the issue. Of course, for the rule of law, this is now a main fundamental issue, because in terms of freedoms, if you are restricting the freedoms with legislation, then you need to pay attention to the circulars as well. This is not the case. We've seen the same thing during the COVID-19 pandemic. We had the general health criteria that were subject to certain bans through circulars of the ministries, not through legislation. So it's very important to talk about this as a structural issue. Now, next question is from Publishers Union of Turkey, Kenan Kocatürk, the president.
I wish everyone a good day. When we look at the speeches made, of course, the freedom of expression was taken up. We talk about the freedom to publish. This is one of the major veins that feed into the thought life of a country. But there are many, many situations where this right is brought under constraint. One of the fundamental articles of the Universal Declaration of Human Rights is about the right to publish. And then Article 19 of our here says that there is an article that the publishing industry takes as its major a fundamental principle. So if there is no violence defended, then this should be free totally as a practice. The Turkish Union of Publishers, of course, pays great importance to the freedom of expression, and it publishes reports on the freedom to publish, and these reports talks about the investigations and the investigations opened up about and the prosecution of publishers, authors, even printing houses, and there have been times, of course, when people were thrown into prisons. We have problems in getting books into prisons. There are many limitations on the right to publish, and there are very serious reports that have been taken even in decisions of the European Court of Human Rights. We defend the framework that is established in the human rights conventions, and we believe in a democratic society. Let me underline certain points from our report of 2021. There were many cases of prosecution here, and because there was an increase in the number of cases with respect to the crime of defamation. In prisons, there was constant violation of the right to access to books, and you can always read this on the website of the Turkish Union of Publishers. One of the most important problems is that the decisions of the Committee on the Protection of Children from Harmful Publications have increasingly encroached upon the freedom of expression. Now, this institution is now a part of the Ministry of the Family and the Child. This board decided that 6 books were against general morality and was harmful for children. And then 24 books also were included in the list. If you look at what is considered to be the harmful book among books which sold millions all over the world, these are books that talk about how children are born and similar matters. And with respect to the decisions of prohibition, there was something very interesting that happened. A lawyer went to court to stay the execution of this law, the decision of this board, and this is a very important decision for us. It's interesting. Beyond publishers and jurists, lawyers, the state decision involved as its reason the prohibition of a book that teaches the daughter of the person who went to court the rights of a girl. So this is all I have to say, Turgut Bey. Thank you for your contribution. And of course, sectorally too, you touched upon the freedom of expression, because this is really an organized and institutional front of the freedom of expression. I was going to touch upon that. You went into it directly, together with this economic aspect. If I'm not mistaken, the publishers really, the publishers world really work on imported inputs from paper all the way to the machinery for the printing press. And so this creates a lot of economic cost for the publishers. So one would even expect a positive kind of intervention on the part of the government. The negative side, of course, is very important within the overall criteria of freedom of expression, but also the positive side is important. Because of the economic constraints, there is a positive responsibility of the administration vis-a-vis this industry. Perhaps we can bring this out in much more detail in the second round. Thank you, Kenan Kocatürk. Now, I have on my list, we will pass over to TESEV. Bekir Ağırdır from the board of directors will be our speakers. Hello, we are talking about such a topic that Arus Yumul said at a certain point that certain problems in Turkey have become brands, commercial brands, so to speak, and the freedom of expression is one of these. There are many, of course, questions that come on the agenda on a very topical manner. The topical aspect is this. According to our registers, 100,000 people died in the pandemic. We weren't able to learn the number of casualties in the pandemic correctly. We don't have the right to learn this kind of thing. Our access to information is limited. It's not only the freedom of expression. This kind of obstruction of the flow of information really also interferes with our right to correct information. Another aspect, our relationship with truth is really upset and corrupted, because only within the limits of the spheres where the government permits, we can learn information. So there is a kind of corruption of our conception of truth. Well, echo rooms is what this is called. There's a perception of a different reality here. And even more importantly, what's more topical is the question of elections. Within the coming 12 months, Turkey will be experiencing elections. This really is a sine qua non in democratic regimes. People have the right to change the government. What does this mean? This means that all opinions have the right to organize and to put forward their ideas, their theses, their policies without any restriction whatsoever through the freedom of assembly being enjoyed. And the electorate, looking at the different candidates and having access to information regarding all the different candidates and their opinions. This is what democracy is. If you want to have the right to change democracy, the government through elections, then you need this. But there is really restrictions on the freedom of assembly. The police has immense powers against all kinds of political manifestations. And so how does the electorate have access to the different ideas? So beyond our problem, almost everlasting problem of the freedom of expression, we're now face to face with a much graver problem when we talk about the elections. The state and those forces in power look at the whole question from the point of view of the state and the government, and not from the point of view of citizens. All the freedoms and rights of citizens in spreading their ideas, in imparting their opinions to the rest of society are trampled upon. So the coming election is a question between freedom or authoritarianism, welfare or poverty. Because there again, there's another problem. The definition of security, both of the state and of the government, is really restricted to the security of your borders. And if you talk about the borders, of course, the question becomes a military question. But when we talk about the pandemic, if you do not take this as a question of social security, if you don't see unemployment and poverty as a security problem, if you restrict the question of security to only borders, then you can, of course, see it as a question of terror and look at it as a military problem. And all the military and civilian state apparatus is really doing this at the moment. But despite everything, there is the habit of truth to not to remain hidden and to come out and show itself. Will this rule over the restrictive policies of the state in the coming period? We will live to see which one will overcome. Thank you very much, Bekir Ağırdır. I find your emphasis very important. Processes and consequences or results. Of course, we can only define the results that we obtain in democracies through processes. Decision-making processes, electoral processes, etc. When Turkey was changing its constitution some 10 years ago, as a group, we talked about the following. The preparation of a constitution is a process. It's not only a matter of a result. Well, you can shut yourself up in parliament and prepare a constitution in 1 week. But this is not a matter only of results, but also processes. For this to be a democracy processes, the society has to breathe, and the instruments for this are, of course, the rights and the freedoms. And the second important question, this question of security versus liberty or freedom has now become a kind of cliche, but here there are certain freedoms. You cannot really take these freedoms up on the basis of the criterion of the balance between security and freedom. For instance, the ban on torture. Can you take this up from the point of view of security versus freedom? No. Only if you protect in a very delicate manner freedoms, fundamental rights and freedoms, then can you talk about security. So this is really very hard for us to accept, and therefore I found the emphasis on processes, especially with respect to the processes of the electoral event that's going to take place, and also the preparation of a constitution. Thank you, Bekir Bey. This is the end of the first round. Now I will pass over to the second round. I want to use our time carefully. Well, we do have enough time, and our speakers, if they think that they haven't been able to express themselves adequately in the first round, they can go into detail in the second round. Now, let's start again with the Human Rights Association, Öztürk, Türkdoğan.
Öztürk Bey
Yes.
dahil mi?
Mr. Öztürk, is he here? Because I think he left us for a minute, but he was supposed to be back by now. I think he has a connection problem. Apparently, he has a connection problem. So let's continue with our next speaker, Coşkun Üsterci. I think he is here. Yes, the floor is yours. Yes. Well, first round was a very nice round. All the speakers said things that really complemented one another. I would like to dwell on the same topic in this round as well, because I wasn't able to mention some of the things that I wanted to point out. But you, other speakers, and especially Mr. Bekir, made such nice statements that what I wanted to say was already addressed. For instance, Mr. Bekir, he talked about truth in terms of restriction of rights and freedoms, how truth was distorted and changed with the restriction of rights and freedoms. That's what he talked about. So within my remarks, I quoted our representation in the province of Van, our physician and our representative in Van have been sued, I said. So let me refer to that case. Last year in October, on the 23rd of October, there was a traffic accident in Ankara. And in Ankara City Hospital, in the gynecology department, Dr. Rümeysa Şen, a young assistant physician, after being on duty for 36 hours consecutively, was going back home and very sadly had a traffic accident. A car collision with a big truck happened, and the physician died on the scene. But when there was an investigation into why this accident happened, it has been demonstrated that it was due to long working hours, and this was considered as an occupational murder. So the Turkish Medical Association's relevant branch working on assistant physicians worked on this, and this heavy working conditions of the assistant physicians was subject to this report, and it was suggested that these working conditions should be improved. There was a call made by the Turkish Medical Association. So this call made by the association, which falls totally under the framework of freedom of expression, just to convey a problem to the decision makers, asking for, demanding for a change. That was the only thing they made actually. However, almost in 20 cities in Turkey, in front of the hospitals, healthcare workers and assistant physicians made a press statement, and there was no problem in any of the cities. However, in Van, when they wanted to make the same press statement, they were told that they had to get a permission from the governor's office because there is a decision. So there was an intervention, and Dr. Hüseyinyaviç and Sevim Çiçek, our representative, have been detained, and then under the law 2911, they were subject to a lawsuit. Charges were pressed against them in terms of violating this law, and we went to see the trial. But the most important part of this truth is that Dr. Rümeysa Şen, who lost her life because she was working under such heavy conditions, was not even mentioned because we were talking about other things. Even the prosecutor who prepared the indictment didn't even touch upon this aspect of the issue. He just said there is a law, you breached the law, you violated the law, so such and such articles of the law were violated, he said. So this mindset of banning all the actions to reveal truth is actually distorting the truth itself. The second thing I would like to dwell on is that, again, Mr. Bekir talked about these policies of security and securitization, so to speak, in all walks of life, the public sphere, political sphere. They want to have a total crackdown on this, and they want to shrink the civic space for people's participation. So this is an important tool that is being used in terms of the legal rights. That's the main mindset. They always show excuses such as public security, and they bring all these restrictions. So this policy of securitization is under all these efforts, and it's very harmful for our democracy if we have one in our country. So again, Mr. Bekir talked about the elections, the upcoming elections. As long as these bans continue in places like Van, Hakkari, Mardin, cities where we have all these bans implemented in an uninterrupted manner, I really am asking myself how we can really have safe and secure elections under such conditions. Let's imagine that during the elections there was a pause, but do we still have a guarantee that the civilian administrations who hold the authority will not make use of these in the future? So to prevent some election propaganda. And maybe last item that I can say, all these restrictions and limitations now being going beyond legality or legitimacy is not the discussion that we have. Now there is no right or freedom. The rights and freedoms themselves have now been almost abolished. No one can use their rights, enjoy their rights or freedoms, and this is how severe the situation is. And these are the things that can only happen under fascist rule. So with that, I'll end my remarks for the second round. Mr. Coşkun, the audience also have a question, as you touched upon this. Maybe other speakers have already talked about it, but rather than rule of law or lawfulness or legality, is it also a problem of unlawfulness? So maybe even the laws are not being enjoyed. So being a country with rule of law is, of course, something different than being a state with laws. So let alone discussing the rule of law, maybe we are not even exercising or implementing the laws. So Miss Fatma also talked about circulars and hierarchy of norms. So this is also important. With your permission, I'll just say one more sentence. There is this approach of dichotomy in the state, norm state and measures state. So now the administration is acting in a totally arbitrary manner based on their perception of threat. So they are making the decisions totally on an arbitrary basis. And there is a dichotomy here, I believe. So yes, of course, in literature, quote unquote, not the law per se, I'm not talking about the martial law itself in Turkey, but when we look at the terminology of field of political science, it is defined as such. And in the Roman era, they say state of emergency does not require right people with rights or who are just, let's say. So even from the Roman times, we have the saying. So throughout the entire history of mankind, we have been facing this problem. So, okay, with that, I'll give the floor to Mr. Öztürk, who was not able to connect before.
Yes, I greet everyone and thank everyone. Well, because I had connection problems, there was a problem. Let me continue from where you have left off. You know, as you know, Turkey's regime changed in the constitutional referendum in 2017. What is called the state system, presidential state system, it has changes the regime, and the foundation of this new regime is constantly continuing. This is a question of state of emergency. The powers of the emergency, state of emergency, were extended several times after the failed coup. And legally speaking, we are in that kind of situation. And this, of course, has really a great impact on civilian administrators. So the new system is really not a separation of powers, but a unity of powers, because the president of the Republic has all the rights to appoint everyone, and he is also a de facto executor of the laws. This way, people imitate him, that is to say, the civilian administrators, representatives of the central government. You see this in the judiciary as well, and it's very difficult to cope with this. This is a structural problem. Turkey has to find the route to a transition to democracy. We have to really think hard on the method for this. The question of the regime change is very important, and it has created its authoritarian practices. I would like to underline this very particularly. Then there is another tendency that's developing. There is this concept of nativist and national. Eren Keskin, a previous president of our association, was tried in the case of Özgür Gündem, a newspaper published by pro-Kurdish circles. She was convicted, and then among the reasons of the conviction was that the court thought that a native and national conception of human rights should be established in Turkey. This is incredible. There is a universal declaration of human rights, and the decision of the Council of Ministers that adopts this declaration says that this should also be taught in school. They don't even know about this, or they do it on purpose. And now this has the appeals court has turned this down, and it has gone to the High Court of Cassation. The most important characteristic of human rights is that it is universal, that is valid all around the world. It is based on conventions, and it is a developing law. And the judiciary can dare ignore this. We can give many examples here, but the citizen really has been divested of the right to be a subject. This is a regime of uncertainty, as some people use this expression. I will too. When we say let's speak about the freedom of expression, we have to talk about the authoritarian structure of the regime itself, because these are totally connected to each other. Within the context of the human rights defender situation, in particular, the change, together with the change in the law on associations, now human rights association is now considered, well, all organizations of human rights are considered to be very dangerous now. And then the changes, the amendments in the law on fundraising, it makes the sphere even narrower for the future, because you cannot subsist without, of course, this kind of fundraising through donations. So the deterioration of the law on associations, the abuse of other kinds of legal texts, and this new draft law that will really bring a military discipline on social media really is a reflection of the so-called People's Alliance, which is the alliance in power. In the coming period, in the coming electoral period, this is a question that all citizens have to pose themselves. Either this authoritarian regime, this repressive regime will continue, and the freedom of expression will be impossible to use, or things have to change. Because if we cannot speak, if we cannot organize, if we cannot use our freedom of assembly, we cannot talk about any of these rights. I think the social opposition should be in a very serious struggle together with the political opposition. A change in government really should bring to the fore the question of where were we before and how can we get back there. Thank you. Thank you, Özgür Bey. Öztürk Türkdoğan, sorry. Let me share with you some of the questions our speakers may wish to touch upon these. One I had already shared. The question of the limitation of the freedom of expression related to insulting the president, and to what extent can the executive have an impact, have an influence on the judiciary. The question of hate speech, to what extent, what are the limitations of this? There are questions regarding these. If there are people who wish to put forth their views on these questions, Öztürk Türkdoğan or Coşkun Öztürk. Öztürk Türkdoğan. With respect to hate speech, as I would like to say a few words. In our criminal code, there are 5 different provisions in 5 different articles, but these are wanting because there is no sexual identity, the right to sexual identity or gender identity. That is not taken up. The question of different kinds of faiths coexisting, or there are certain arrangements that protect the practice of the Directorate General of Religious Affairs. In practice, we are face to face with a very different situation. If you are against war, then you are accused of inciting hatred within the people. This happened to the Union of Turkish Physicians. We, for instance, the hate speech of the Directorate General of Religious Affairs was criticized by the Ankara Bar Association, and the board is now being prosecuted. We are being prosecuted for answering the Minister of the Interior. So they are really reversing the laws and using them upside down or inside out. In Turkey, the propaganda of war is really prohibited in the criminal code, but this is, it's really, what is really prohibited is to struggle against war. And this is not only a matter of, practical implementation. This is also because the executive has the powers to direct and manage the judiciary in any way it does so. Everything is upside down in these spheres. The Covenant on Civil and Social rights or freedoms, has a provision which really rules out the defense of war. And with respect to hate speech, Turkey is signatory to many international conventions which ban national and linguistic speech, hate speech. We can perhaps link these up with some of the questions that have been put forth by our audience. Now, with respect to migrants and refugees, there may be a relationship between Article 20 of the Covenant and this question. So, our route, when being depicted for reaching our rights, we need to use this has to be according to the standards of international conventions and covenants. Of course, lawlessness or non-compliance with laws should also be taken into consideration. This is a kind of public attitude to an ignoring laws. Now we will continue with Kaya Kartal.
Thank you, Professor. I'll start with the question. Freedom of expression, the limitations or the limits of freedom of expression. When is it to be considered as freedom of expression and when is it to be considered as an insult? Well, we have, of course, main criteria listed in the European Convention of Human Rights and other conventions. First, prevention of crime is a very clear criteria, or if there is an insult or defamation to the personal rights of a person, then you can restrict or limit a person's right to express themselves. Or if it's going to impact fair trial, then again, it's listed in the convention. But of course, the problem happens in practice. Of course, you can criticize certain shortcomings in the texts, but the protective measures prescribed in the texts are not implemented in a standard manner for all people. They are implemented only for some people and not for others. In terms of prevention of crime or instigation to hate and hostility, for instance, if these people are members of the government or supporters of the government, let's say, if this happens on their side, then nothing happens. For instance, all the speech and expressions against the migration is out there. Migrants are out there for refugees. There is even very clear instigation. And we have very severe speech, almost amounting to racism or xenophobia, but no sanctions have yet been put upon the people who say these statements. But any criticism against the state and government are immediately sanctioned, and it's considered under instigating people to hostility, and it might even evolve into a point where it's considered as a breach of the anti-terror law. So let me continue from where I left in the previous round. In terms of the Turkish Penal Code, I've talked about certain crimes, and I said that the trials are being used as a stick for the dissidents, and it's not limited to the courts only. Most recently, especially during the enforcement stage, we see this freedom of expression and opinion. If it continues in jail, if people continue to act in a dissident manner in prison, they might also face some disadvantaged treatment in their enforcement phase. Of course, after the 15th of July failed coup attempt, we have seen some legislative arrangements considered as amnesty. The government clearly said that it's not amnesty, but it was obvious that these probation measures were an amnesty. And those that were sentenced within the framework of the anti-terror law were exempt from this. And I've talked about these, by the way. I said that most of these were prepared to suppress the dissidents. So freedom of expression was again limited in the prison as well. And it's not only excluding these people from these new arrangements in the enforcement law, but we also had this probation services. They were excluded from benefiting from probation services as well. So there will, with the law 7242, there was an amendment in the enforcement law, and previously this was criticized, by the way, saying good conduct shall not be an excuse. And now there are committees that are formed to assess the good conduct of the inmates. And as a result of this assessment, they decide whether or not the inmates will benefit from probation or other awarding systems within the prison. But when it comes to the dissidents, again, we see a very negative trend. majority of the applications for benefiting from probation have been rejected by the prison. They cannot benefit from the sentence reduction based on good conduct. So an inmate sentenced to 6 years and 3 months before this arrangement, after serving the prison time of 3 years, they would be able to benefit from probation. So before this was the case, but now they have to serve a prison time of at least 4 years, 8 months to benefit from this. Sometimes the duration exceeds even this 4-year, 8-month period, exceeding all the way up to the release time. So this is unacceptable. When you receive a sentence of 9 or 10 years, and if you are able to benefit from probation services, some of the people don't even serve one single day in prison. You imagine you are sentenced to 10 years and you don't even go to jail for 1 day, but you are sentenced to 6 years, 3 months, but you stay in jail for 4 years and 8 months. So this is a very disadvantaged and problematic issue. So criminal proceedings are actually creating another problem for these victims. One final remark I would like to say, of course, you use freedom of expression through language. As a chronic problem in Turkey regarding language, we have this increasing nationalist trend. Before we had this issue of Kurdish, and sometimes there were some arrangements or some more flexible, let's say, implementations, but it has always been problematic for the government side. Kurdish was always immediately considered or associated with terrorism, use of Kurdish language I'm talking about. And sometimes people were reacting when they heard Kurdish being spoken. Now, along with Kurdish, we have Arabic that is now seen in the society. We see many signboards in Arabic being removed all over the country very recently. Racist discourse of many parties are now showing or having some implications on the government's behavior. In terms of the language, Arabic, well, Arabic had a more advantage compared to Kurdish, because in Kurdish we've never seen such an easy use, but now this discourse of one language is now being emphasized. So language as an important instrument for freedom of expression is now being suppressed. So with that, I'll end my remarks. Thank you. Thank you, Mr. Kaya. You emphasized equality. I think this is very important, especially in terms of the enforcement regime. Making an emphasis on equality is very important. Freedom of expression should also continue under a different legal regime. What you said is this, so it should not be creating an unequal treatment. So in terms of different social relations, this can manifest itself as a behavior. So equality in terms of enjoying the rights is also important. In practice, of course, we have this positive duty to eliminate inequalities, but what you were emphasizing was very important. We have this positive obligation, but inequalities in practice are also very widespread nowadays, you said. Thank you for raising that issue. And now let's continue again with Fatma Bostan Ünsal from the Association of Initiative of Rights, Secretary General. The floor is yours. Yes. Although the state of emergency has officially ended in Turkey, in practice, it still continues, as mentioned by the previous speakers. Still, people are not able to benefit from their rights arising from the law number 657 on civil servants. And in many other fields, this is also continuing. And this is the first time ever this is happening in Turkey after the 1960 we have seen after 1 year the state of emergency was lifted, but in many places in Turkey, since the last 6 years, we have in practice the state of emergency that is being implemented. A couple of days ago, the leader of opposition announced his views, and the TV channels that actually broadcasted that were issued monetary fines just for broadcasting it. So just like Mr. Bekir said, this is also preventing people's right to have access to right information. So these TV channels or broadcasting agencies are being sanctioned just because they broadcast the statements of the leader of the opposition. Again, Mr. Bekir talked about these echo chambers. So everyone has their own truth now. Everyone has their own version of the truth. I wish we would have one single truth, especially in terms of news. Remember Trump's lies. That was the block they created at that time, and I think we need something like that in Turkey. We sometimes have information supported by data, but when we're talking to people, very close people to us from the opposite side of the political spectrum, when you discuss something, well, there is no grounds for any discussions anymore because we are now facing a society that is detached totally from the truth. So when we look at this draft law on disinformation, of course, we have some suspicions about this because of the practices of the government, but as it's always the opposition that suffers from the implications of the new law, an independent group should be there to make some efforts to prevent disinformation. Of course, laws and legislation should be there, prepared by the government, because it's clearly seen that even sometimes the facts mentioned by the opposition are considered as disinformation and are subject to sanctions. But any statement that are definitely wrong or lies, if it's coming from the government side, it's subject to no sanctions. We've seen it in the Gezi protests. The statement saying that people drank beer within the mosque, although it's obviously a known fact that this never happened. This is now being said. So just like the Trump lies in the US, we can have a similar initiative in Turkey. Regardless of who is telling out those lies, they should be identified so that we will not lose our touch with reality and we will be able to come to a consensus. Yes, you talked about the difference between rule of law and a state with laws. It's true. If you sometimes you might have certain laws to threaten certain rights, but we see in Turkey that some of the existing laws are not implemented by the government. Deferral of the enforcement of the jail terms for pregnant women, for instance, is something that can be made use of according to law, but in practice, this is not the case. So the administration is not abiding by its own laws sometimes. So our job is to express this so that the government will implement its own laws. Again, hate speech against asylum seekers or refugees. The Afghanis were the most recent victims of this. One was killed, another one was injured in the Black Sea region. So they were blatantly subject to hate speech. They were victims of hate speech. So we should be protecting the weak here. But now, it's in the hands of the majority and the government, and it's used to punish and threaten the opposition or minority. Again, anti-terror law, this very, very wide interpretation of the law has totally caused a collapse in the judiciary system, accusing millions of people with being involved in terrorist activities, and trying them like this will, of course, make the judicial system collapse, which has been the case. So those who were accused of and sentenced with being involved in terrorist activities, 2 million people we're talking about, as always, as we say always, even the journalists, when they are also considered as people who have committed crimes within the framework of the anti-terror law, their press cards are cancelled, and this will also further negatively impact the freedom of press. I'm sorry for exceeding my time. No, you haven't exceeded your time. So thank you. This issue of truth, before we talk about this, getting information and news is also a part of freedom of expression, as you emphasized. But now it's going even beyond this. It's beyond getting information based on facts. But those facts, to what extent are they real or not? Now there is another sphere of getting the right of getting informed in terms of reaching out to that truth. So now this is also an instrument turning into this right to be informed. So this right to get access to the truth, to learn the truth, is now considered as a new right. So we can discuss it in different dimensions for today or for past, but we call it infodemia in the new age. So this is a new fact that we are facing. So you're very right. Now this is a new threat against freedom of expression. And it's a serious one, especially the political governments, the parties in power are manipulating this as an instrument. We have many different examples from all over the world. And now this is an important threat for freedom of expression. So thank you, Ms. Fatma. Let's continue with Mr. Kenan from the Publishers Union. By the way, we have some direct questions referred to you. I will share them, so you might have a chance to answer them during your remarks. One question is that, different than the past, in terms of this freedom of publication, in terms of violations or interventions, what are the new different mechanisms? What is the trend now compared to the past? What is different now in terms of intervening in this? Another question is about book publishings, especially through social media. Certain publications are now being targeted, and some campaigns are now being pursued to prevent or intervene in the publication of such books, or some negative campaigns are increasing, they say. So what do you think about this? So with that, I'll give the floor to you. The floor is yours.
I was going to talk about these, so thank you, those who have asked the questions. Let's remember the past. People of our age, well, Öztürk talked about this. There were these articles 141, 142, 163, even 146. And we went through, people were prosecuted on the basis of these, and publishers really were also the target. And Erdal Öz, for instance, was he published the Tropic of Cancer, and he was prosecuted for that. And so the resolution of publishers to defend this right was really touching. But so many things happened in between. Then there was the Article 301, the protection of Turkness. I was also I was also prosecuted for this because a novel that I published said the Turks' mouth stank, and so I was taken to court. And then there was, of course, the anti-terror law. Today, although there's a diversity of reasons. One is that through social media, let's say, starting from a fictional character, people were socially lynched, so to speak, or because an author was the representative of a current of thought, both the author and the publisher were also lynched. Well, we think in the following manner. I'm not a jurist, I'm not a lawyer. Perhaps you can interpret this better. We think that we know that we have constitutional our constitutional rights. Well, when the publisher publishes a book, takes it to the prosecutor for publishing, and within 6 months, if there's nothing, then it cannot be subjected to any kind of prosecution. But today, well, just as we had taboos in the past, the protection of Atatürk, or the Armenian question, etc., etc., and now there are new taboos. The word Kurd, for instance, Kurdish, is a no-no. When these books are distributed to the different districts of Anatolia, they are banned, and we don't even know of these prohibitions. There are also other things that have changed. Right? Let me give some examples a moment later. There is, for instance, the Board for Peace. Well, people complain to the presidential office with regard to books that disturb their conservative conception of life, and this Board of Peace or Social Peace says we do not ban these books, we simply put them in plastic covers. Sometimes our authors and publishers go to book fairs in certain regions of the country, and outside the social lynch, so to speak, on social media of radical authors. For instance, in Kayseri, İhsan Eli Açık, who is a Muslim author, but one who is in opposition to the government, was almost lynched by a group organized by, let me say, the municipal police. Then a stand which had a book by Selahattin Demirtaş was also brought down by a group. So people really have to protect their lives in these kinds of situations. When we look at this kind of thing, these lynching campaigns through social media really are detailed. Now, as I was mentioning this Board of Social Peace, they also banned books for adults, calling them harmful. The Osama book, heart palpitation of the heart, was put under a strenuous situation and there was this discussion. This was on Netflix, and Netflix said this was 18 plus. But so we find, these kinds of strange situations. Another colleague said this a moment ago, the question of books going into prisons, or the book Efsun, authored by Selahattin Demirtas, the leader of the HDP, is not given to certain prisoners in Bolu. Then a book of poems was not given to prisoners because it would upset peace in prison. There are court cases against a book edited by the CHP, the second biggest party of Turkey, which is titled the Autocratic Incorporated, that is to say, a company that is under the control of Tayyip Erdogan. There are other books that they want to seize, and there was a warning sent to the publishers. The publishers simply ignored this, and then the police went to the publishers' publishing house, and they asked for all the contracts with the authors. There are people who complained about these books, they said. Well, some of these we did not even experience under the military regime of 1980, 1983. Well, the method was different. The military dictatorship let us publish our books and then took us to court. But now things are different. I think it was Kaya Kartal who said this. We, of course, should defend also the rights of prisoners. And then there's the question of language. We know, and we say this, we have said this for years, the publishing industry is a strategic sector, but the privatization of paper mills and the closing down of paper mills really created an immense problem, and publishing became totally dependent on imports of paper. And this is one of the lessons that we have learned. And under this repression and the use of criteria in order for books to be purchased for libraries, there are complaints that are sent to the president's office for grievances, GİMER, about books from provincial districts. We also see that, of course, as I've said before, that certain books cannot enter prisons. On the basis of these taboos, there is, of course, the worry and the concern of publishers to be prosecuted, and they, really turn to a kind of self-censorship. Well, the book I mentioned a moment ago was supposed to be published 3 years ago by another publishing house, but they were threatened for this book, and therefore they gave up the idea. Now it's another publishing house that had this book translated and published, and is now in deep trouble. And after the publication of books, although there's a 6-month limitation, as I said before, we see bans after 6 months as well. Is this peculiar to our country? I am the Turkish Union of Publishers. The Union of Publishers of Turkey is one of the most active members of the International Union of Publishers, and are very highly regarded by this institution. I am chosen to the board of directors of this International Union of Publishers. The problems that we have talked about are not peculiar to us, but we are at the head of these people, these violations. There's a Voltaire award given out by the International Union. Turan Günay was given this award in 2017. He and the Evrensel Publishing House together. Another special award was given to Hrant Dink in 2007. In 2022, the Dar el Jaded Publishing House of Lebanon was awarded this prize in 2022, where the owner had been murdered in 2021. We look at the candidates for the award this year, one from India, one from Thailand, one from Guatemala, one from Afghanistan, and one from the Ukraine. But while this, all these publishers come together in solidarity, in Norway, for the first time this year, a World Expression Forum was established. They want to create a structure similar to the World Economic Forum, and there will be a forum convened at the end of June, and the situation in many countries will be discussed. This is a forum that will look at prohibitions and repression all around the world. So other countries are afflicted with the same problem, but this fundamental problem is, of course, the question of fundamental freedoms. Other questions are on the agenda that really act as barriers to these freedoms. We don't see these in continental Europe. Our Korean colleagues for a long time waged their struggles. They finally won their rights and freedoms. We also, as publishers, authors, and translators, are waging the same struggle, and our struggle will continue as long as these prohibitions and repression continue. I do hope that in the future our children will have access to a world free of these barriers. Next year, if there's no violation, and we're giving out these awards for those authors and publishers whose work is hampered by the prohibitions and the repression. We are not going to give it 1 year when this kind of violation does not take place, but unfortunately for some time we will continue. Thank you, Kenan Kocatürk, for this. This grievance mechanism, the presidential office, this is of course, a violation that is called of the type vertical violation, and then there are violations that emanate from society at large. That's horizontal violation. Under the military dictatorship of the 1980s, I was an assistant lecturer, and Bülent Ulusu used to send, that is to say, the prime minister of the period used to send circulars to universities. For instance, the liquidation, the removal of Servet Tanilli's History of Civilization from libraries. There was an exhibition on human rights, and I gave the History Foundation some support. Well, I was asked for some curatorial support. I couldn't do it because I was abroad. Bülent Tanner helped them out, and there it was mentioned, the elimination of Servet Tanilli's History of Civilization from libraries. This is under a military dictatorship, and today we have a very hybrid kind of political regime. It's not only a matter of expression that is being trampled upon. We also live in a world where people who violate these rights really take their cue from other countries where violations are also practiced. Bekir Bey, the floor is yours. Oh, I'm sorry, there's a question directly to you. Let me read it to you. Are we face to face with a kind of retrogression in politics compared to the early 2000s?
Okay, I'll start with that. I don't think so. On the contrary, with the pandemic, economic crisis, authoritarianism rising, with all these things, thanks to all these things, let's say, as a positive outcome of all these processes, there is now, I think, an increase in empathy in terms of accepting the existence of one another. I think there is a serious improvement, mentally at least, in the society to be able to understand the others. But this mental transformation is not reflected into practice, as mentioned by all friends and activists here. And simple citizens cannot even dare to do that much. There is a transformation in the mindsets of people which they cannot reflect into their behaviors and into practice. And just like you said, Professor, and just like Mr. Kenan said, we are now face to face with a global democracy crisis. I call it the intermediary ice age. We have the climate change, technological advances that are happening. And with all the change happening in many countries, there are certain sections of the society who are concerned if this change will create a problem. We don't have Le Pen and people like that by coincidence. The climate is now available for this. But in Turkey, the situation with CİMER, the communication center of presidency, and all the applications made to CİMER, trying to gather all the information here. Although this might look like a very individual evil, I call it an organized evil. I think through the civil society efforts, they are getting organized. Social lynching or the lynching activities on social media are not happening by coincidence or by themselves. I think there is a manipulation here. People with evil intent on social media, through GMAR, or through the judiciary, they believe they might have an influence on these authorities, and they're getting organized to do this. So I don't think this is an individual issue. I think this is a very organized issue. That is what I believe. So against that, of course, we have so many activists here presented. I don't need to explain what they are going through in their everyday lives, but let's try to focus on what we should do. And here I have a twofold recommendation set. First, things we can do and we should do on an individual level, especially regarding all these conspiracy theories or manipulation of this organized evil. We should make our best efforts not to be an instrument of this, not to be manipulated by this, because we cannot think ourselves free of all this change and deterioration of the society. We are also, of course, being impacted by the deterioration in the society. So let's avoid immediately retweeting any message we say without confirming if it's false or right or false. Let's try to avoid sharing any message we get on our WhatsApp groups immediately without verifying the source and its truthfulness. So people should also pay more attention to fact checking, actually. So let's not be an intermediary of spreading of misinformation or fake news. That's one. Number two, having principles is important. Sometimes we do it ourselves also. Let's learn to make the distinction between a crime and a mindset. Struggling with a mindset can be done in the civic or political sphere, but in our own sphere, sometimes there are attempts for social lynching, and climates available for this sometimes happens. So let's not fall into this trap. Another issue is discrimination and hate speech. Not all sections of the society, all groups or clusters have a concept of the other. And otherization can happen very immediately. For instance, the issue of Syrians most recently, almost 90% of the country have fallen into the trap of this information on Syrians. Even people we think to be smart are falling into this trap. Another thing is that decision makers, not only in the civil society, but business people also who are at decision-making levels, I'm sure we have such people in the audience, we have to admit the fact that freedoms are to be considered with a holistic approach. If you're talking about innovation, R&D, entrepreneurship, there is a huge amount of money allocated, incentives for this, as we know, but for instance, your IT developer or clothes designer, their freedom is something different than the freedom of Selahattin Demirtas. Do you think this is the case? This is a holistic story. We have to voice it out every time we have the opportunity. To everyone, we have to say this. So without this, if we don't have this holistic, integral climate of freedom, we can't have design, R&D, innovation. We cannot develop or code new games. We can't do any of these things. We have to understand this first. As you mentioned, 2002, Foundation of History had this exhibition on human rights. And it's one of the lines on my CV that I'm proud of, having such an exhibition, the chair of such an exhibition in such an institution was an honor for me. And at that time, we were trying to defend the fact that human rights is an inevitable part of our lives. And just like Hrant Dink has said, our rights are like the voices come from our stomach, right? It's very important, even the right to life, right to clean air. So these are all very important. And we have to do something because these are integral and inseparable rights. But we have to start from one point. For instance, in terms of the freedoms granted to us by the government, we should focus on a new system, a new social consensus. And this can only be done through civic politics. That's what we need to tell people. So if there's a starting point, it's not the constitution, because the constitutional process itself, constitution making process itself creates this. So first we need to free politics, make it natural. From the law on political parties to the law on the rights of assembly and organization, from the laws of associations to the duties of the police, anything that restricts opinions, freedom of expression, anything that prevents us from talking about opinions and ideas has to be cleaned, and new social consensus has to be done through negotiations by the hand of politics. And we need to do this through the processes of convincing people. And we shouldn't just give up saying that, oh, this is the case all around the world. No, we need to build this new political grounds, and this is how we should explain it to the society. Human rights is not a political concept, but it's an issue of pursuing an honorable life. So we have to tell the people, tell the society this. And with that, thank you very much for giving me this opportunity. Well, thank you, Mr. Bekir. I also would like to touch up on the most recent thing that you said, honorable life, you said, or dignity. Living with dignity is very important. For hundreds of years, this has been a main issue for the mankind. But when we take a look from the perspective of freedom of expression, it's about being an agent, not biologically a person, but being an agent. Because biologically speaking, it's not a precondition to have rights. If just because of the fact that you're a human being, it's not automatically giving the rights, but having agency is important. Being able to assume your own responsibility and sharing it freely is also important. So it's very, very important what you have touched upon. And it has to encompass all fields, from R&D to innovation, from space work to all the work we have on the planet, on planet Earth. So we shouldn't, we are living in this environment where our opinions and dreams are restricted. But if it's the case, we cannot dream about or think about the space, right? There are restrictions to that. That would also have its implications on that. So being an agent is all about being a citizen, a responsible citizen, a participative one. I think this brings us to the end of our panel. I'm looking at the time. I personally benefited a lot from this panel. I would like to thank all the speakers, Öztürk, Türkdoğan, Coşkun, Üsterci, Kartal, Fatma, Bostan, Ünsal, Kenan, Kocatürk, and Bekir, Ağırdır. I would like to thank you all for sharing your contributions, experience, and your opinion, and making us and supporting the joint civilian initiative. So we will continue first with testimonies and then with another panel. I would like to wish you all a free...
İnsanın doğa üzerinde kurduğu tahakkümün sonuçları yıkıcı sonuçlar yaratmaya başladı. Yerkürenin kritik ısınma eşiğini aşması artık an meselesi. Bu yalın gerçek karşısında bile bırakın önlem almayı, kar hırsı uğruna doğanın tahribatı var gücüyle devam ediyor. Binlerce yılda oluşan ekosistemler, barajlar, maden sahaları, yangınlar ve kesimlerle yok oluşa itiliyor. Başta yıkıma uğrayan bölgelerin yaşayanları, aklı başında her yurttaş ise buna itiraz ediyor. Kamu otoritesi zaman zaman bu yıkımın doğrudan sorumlusu, zaman zaman da bütün olanaklarıyla fail şirketlerin koruyucusu. Yıkım büyüdükçe mücadele de büyüyor, mücadelenin önüne konan engeller de. Orman yangınları bile yayın yasağı konusu. Ağacına sarılan yurttaşlar örgüt üyeliği, kamu görevlisine direnme ve başka onlarca suçlamanın muhatabı. Ekolojik yıkıma itirazın yükseldiği her bölge sabahına varmadan eylem ve etkinlik yasağı sahasına dönüşüyor. Yıkım sahalarında nöbet tutan kolluğun müdahalelerinde onlarca yurttaş gözaltına alınıyor. Kamu idaresinin ve şirketlerin hukuk ve medya ordularının seferber edildiği yıldırma davaları ile karşı karşıya kalıyor. Özetle doğaya, ağaca, toprağa sahip çıkmanın suç olduğu bir ülke Türkiye.
Biz ekolojistler yaşam alanlarımızı savunmak için yürüttüğümüz mücadele sırasında çokça hak ihlallerine uğruyoruz. Aysin Alioğlu Büyük Nohutçu, Metin Lokumcu, Avukat Cihan Eren dostlarımız gibi bazen yaşam hakkımız bile elimizden alıp katlediliyoruz. Kaz Dağı Doğal ve Kültürel Varlıkları Koruma Derneği olarak kurulduğumuz 2012 yılından bu yana çeşitli haksızlıklara ve ihlallere maruz kaldık. Takip ettiğimiz çevre etki değerlendirme süreçlerinde halkın katılımı toplantılarına zaman zaman şirket ve kamu görevlileri tarafından alınmadık, katılımımız engellendi, tartaklandık, sözümüzü söylememize izin verilmedi. Basın açıklamalarımıza, mitinglerimize müdahale edildi, tartaklandık, yerlerde sürüklendik, gözaltına alındık. Pandemi fırsat bilinerek getirilen ormana girme, drone uçurma gibi bazı konularda yasaklamalar ve sınırlamalar getirilerek mücadelemiz engellenmeye çalışıldı ve ciddi miktarda para cezalarına çarptırıldık. Basında hakkımızda asılsız haberler çıkartılıp iftiralar atıldı, itibarsızlaştırmaya, küçük düşürme ve kriminalize edilmeye çalışıldık. Ajan olmak, istihbarat örgütleri için çalışmak, Alman vakıflarından para almak gibi ısmarlama haberler yaptırıldı ve bu haberler sonrası sıkı denetimlere uğrayıp gözdağı verilmeye çalışıldık ve yüksek para cezalarına çarptırıldık. Hakkımızda davalar açıldı. Yıkım ve talan projelerinin yol açtığı ekokırımların suç olarak kabul edilmesi gerekiyor. Bu konuda uluslararası çalışmalar var. Ekokırımın tanımı yapıldı ve Uluslararası Ceza Mahkemesi'nin ekokırımı da suç kabul etmesi için girişimler sürüyor. Dünyanın çeşitli ülkelerinde iklim davaları açılıyor ve ekokırımlara neden olanların cezalandırılması için çalışılıyor. Bizim ülkemizde de bu konuda benzer çalışmalar başladı ve giderek artıyor. Ekokırımın cezalandırılması ve yaşam savunucularının savunulması konusunda daha fazla destek gerekiyor. Selam ve sevgilerimizle.
Türk Ceza Kanunu'nun 299. maddesi Erdoğan'ın Cumhurbaşkanı olmasının ardından hayatımıza girdi. Cumhurbaşkanına hakaret suçu. Bunların içinde neler yok ki? Sanatçılar, gazeteciler, sosyal medya kullanıcıları, binlerce insan Cumhurbaşkanına hakaret suçlamasıyla ifadeye çağrıldı, yargılandı, ceza aldı. Adalet Bakanlığı ve İçişleri Bakanlığı yıllardır resmi istatistikleri açıklamadığı için kesin rakamı bilemiyoruz. Erdoğan'ın Cumhurbaşkanı seçildiği 2014'ten 2021 yılının başına kadar geçen sürede açılan toplam soruşturma sayısı 160 bini çoktan aştı. Açılan 35 binden fazla davada 38.608 kişi sanık sandalyesine otururken 12.881 yurttaş mahkum edildi, 11.913 yurttaş hakkında da verilen cezalar ertelendi. Halbuki Erdoğan'dan önceki 5 Cumhurbaşkanı döneminde aynı suçlamayla açılan dava sayısı 1816 idi. Daha önce benzer durumlar TCK 299 değil 125. maddesinden yargılanıyordu. Neden? Çünkü Erdoğan o zamanlar başbakandı. TCK 125 devlet görevlilerini hakarete cezalandırıyor. Bir de 301. madde var. Türklükten başlayıp devletin kurumlarına yasama, yürütme, yargı, özellikle de asker, polis vesaire hakareti cezalandıran madde. Aslında bu tür önlemler TCK'nın 299-305 arasındaki maddelerinde belirlenmiş. Yalnızca Erdoğan değil, Erdoğan ailesi ve dostları ve ülke bürokrasisi de hakaret davaları zırhının arkasına saklanmış durumda.
Bu Cumhurbaşkanına hakaret kavramıyla biz yeni tanıştık. Yani 2000'li yıllarda AKP iktidarıyla birlikte gelişti bu yargılamalar. Aslında 80'lerde, 90'larda biz düşünce ve ifade özgürlüğü kapsamında pek çok davadan yargılanıyorduk. Fakat bu denli sert ve keskin bir şekilde Cumhurbaşkanı hakaret ithamıyla yargılandığımız bir dönem hatırlamıyorum. Benim bu süreçte Cumhurbaşkanı hakaretten 3 ayrı yargılamam oldu. Birisi İstanbul'da 2017 yılında 1 yıl 8 ay mahkumiyet almamla sonuçlandı. İkincisi 11 ay 20 gün şu an istinafta. İlk yazım bir günlük gazetedeki köşe yazımdı, yargılama nedenim olan yazı. O yazıda bir zulümden bahsettim ve sonuç olarak burada zalim algısı oluştuğu için zalim ithamıyla onu suçladığım gerekçesiyle 1 yıl 8 ay hapis cezasına çarptırıldım. Bir mahkeme masrafı sunuluyor bize. Akabinde 15 gün sonra astronomik bir faiz işlediğini görüyoruz filan. Bunu da anlamış değilim. Bu konuda da bir sektör oluştu Türkiye'de. Yani Cumhurbaşkanı hakaret davalarını alan avukatlar oldukça güçlü ve zengin insanlara dönüştüler. İkinci davam şöyle, 2019'daki Cumhurbaşkanlığı seçimlerinde Tayyip Erdoğan muhaliflerine ve dünyaya ben diktatör değilim demek için seçimlere gidiyor. Başka bir nedeni olduğunu düşünmüyorum demiştim bir Twitter yorumumda. Fakat burada direkt diktatör ithamı yok. Diktatör olmadığını söylemek için seçimlere gidiyor, göstermek için seçimlere gidiyor vurgusuna rağmen direkt diktatör demekten yargılandım. Oysa diktatör dünyanın her yerinde, hani başka dillerde de diktatör C harfiyle yazılır, İngilizce'de bilirsiniz. O kelime anlamı karşılığı şudur. Yani siyasi anlamda bütün yetkileri eline geçiren kişi. Otoriter kişi. Yani bütün yetkileri siyasi anlamda Türkiye'de eline geçirdiğini görüyoruz Recep Tayyip Erdoğan'ın. Fakat bunun adını koyduğumuzda, ya daha doğrusu ima ettiğimizde dahi bir mahkumiyetle karşılaşıyoruz. Ben direkt diktatör demediğim halde 11 ay 20 gün bu yorumumdan dolayı ceza aldım. Bu ikinci Cumhurbaşkanı hakaret davasından 11 ay 20 gün cezam istinaf mahkemesinde. Orada onaylanırsa yine para cezası biçiminde bana yansıyacak.
Basın özgürlüğü, bilgi ve düşünceleri toplayıp yorum ve eleştiri yaparak çoğaltabilmek ve bunları yayımlayıp dağıtabilmek haklarını içeren, haber, fikir ve düşünceleri çoğaltıcı araçlarla serbestçe açıklayabilmek özgürlüğüdür. Bu açıdan demokratik bir toplumun olmazsa olmaz ön koşullarından da biridir. Dolayısıyla ülkedeki basın özgürlüğünün verili durumunu temel hak ve özgürlüklerin verili durumundan ayrı düşünmek de mümkün değildir. Türkiye'de basın özgürlüğünü özetleyen bir tespit yapmak gerekirse, gazeteciler artık mesailerini haber takibi kadar adliye koridorlarında da yapıyorlar. İktidar adli taciz, yasal düzenlemeler, fiziki saldırılar ve karalama kampanyaları, para cezaları, reklam ve yayın yasakları gibi çeşitli yöntemlerle medya üzerindeki baskıyı sistematik olarak arttırırken, düşünceleri ve haberleri nedeniyle hedefte olan gazeteciler işten atılıyor, gözaltına alınıyor ve tutuklanıyorlar. Soruşturmalar, davalar ve yayın yasakları hiç eksik olmuyor. Gazeteciler haberleri, yorumları ve sosyal medya paylaşımları nedeniyle terör örgütü üyeliği, örgüt propagandası, Cumhurbaşkanı'na hakaret suçlamalarıyla karşı karşıya kalırken RTÜK, Basın İlan Kurumu, BTK'da iktidarın yeni sansür araçları olarak işlev görüyor. Medya sektörünün %95'inin iktidarın kontrolünde olduğu Türkiye'de binlerce haberde erişime engelli. Türkiye Gazeteciler Sendikası'nın verilerine göre halen 26 gazeteci gazetecilik faaliyeti nedeniyle cezaevinde özgürlüğünden mahrum. Son bir yılda 31 gazeteci toplamda 52 gün gözaltında kaldı. 60 gazeteci hakkında soruşturma açıldı. 128 davada 273 gazeteci yargılandı. Sonuçlanan davalarda gazeteciler toplam 75 yıl 5 ay 26 gün hapis cezasına mahkum edildi. 57 gazeteci fiziksel saldırıya uğradı, 32 gazeteci sözlü olarak tehdit edildi. 54 haber sitesine ve 1355 haber içeriğine erişimin engellenmesine, 19 haberin içerikten çıkarılmasına karar verildi. Diyanet'in verilerine göre 2022'nin ilk çeyreğinde en az 6 gazeteci ve bir yayın kuruluşu saldırıya uğrarken bir gazeteci de silahlı saldırı sonucu yaşamını yitirdi. Bu, Türkiye'de son 2 yılda işlenen ikinci gazeteci cinayeti oldu. Sadece 2021 yılında 103 olayda gazetecilerin haber takibi kolluk kuvvetleri tarafından engellendi. 112 kez yayın yasağı kararı çıktı. Bir yıllık süre içerisinde Radyo ve Televizyon Üst Kurulu iktidara yönelik eleştirel yayınları nedeniyle ulusal kanallara yayın durdurmayı da içeren toplam 74 ceza verdi. Cezaların parasal miktarı yaklaşık 22 milyon Türk lirasını buldu. Basın İlan Kurumu da 4 gazeteye toplamda 115 gün reklam cezası verdi. Hülasası basın belada. Basın beladaysa demokrasi ve özgürlükler de askıda.
Ben aktif gazeteciliğe 2003 yılında başladım. Hakkımdaki ilk dava 2007 yılında açıldı. Zilan katliamının tanığıyla yaptığım röportaj, halkı kin ve nefrete tahrik, devletin güvenlik güçlerine hakaret şeklinde değerlendirilerek hakkımda dava açıldı, ceza verildi ama o ceza ertelendi. İkinci davam ise 2011 yılında oldu. 2011 yılında İstanbul'da bulunduğum sırada KCK adı verilen operasyonlar kapsamında alındım, tutuklandım ve bir yıl Kandıra ve Silivri cezaevlerinde kaldım. 2017'de yine yaptığım bir haber nedeniyle örgüt propagandası yapmak suçuyla yargılandım ve ceza aldım. O ceza da ertelendi. Hükmün geri bırakılmasına karar verildi. 2018 yılının Şubat ayı, 1 Şubat 2018'de yaptığım yaklaşık 40 haberden ötürü Van Emniyet Müdürlüğü Güvenlik Şube Bürosu'na ifadeye çağrıldım ve orada gözaltına alındım. 5 Nisan 2019'da evim polisler tarafından basıldı sabahın 4'ünde. Onların tabiriyle şafak operasyonuyla gözaltına alındım. 4 gün Van Emniyet Müdürlüğü'nde şubede gözaltına kaldıktan sonra savcılığa yine tutuklanma talebiyle mahkemeye sevk edildim. Mahkemede adli kontrol şartıyla serbest bırakıldım. Bu davada da konu tamamen yaptığım haberlerin işte örgütün amaç ve hedeflerine hizmet ettiği şeklinde hukukta karşılığı olmayan bir gerekçeyle yargılandım. Yaklaşık 2 yıl ben bu yüzden emniyete giderek her hafta pazar günü, özellikle bu konuda pandemi döneminde bayağı bir zorluk çektik. İşte sokağa çıkma yasağı var. Emniyete imza vermeye gideceksin. Bu sefer sokakta polisler kesip yolunu tekrar hayır imza değil evine gidiyorsun şeklinde falan. O dönem çeşitli sıkıntılarda yaşadım. 2020 yılına geldiğimizde 7 Eylül 2020'de öğlen saatlerinde yine evim polisler tarafından basıldı. Neredeyse işte kaldığım evin olduğu binanın etrafı tamamen polisler tarafından kuşatıldı. Evimde aramalar yapıldı. Büyük bir gürültü koparıldı. gözaltına aldım, emniyete gittim. Emniyette işte Osmanlı padişahlarına hakaret ettiğim gerekçesiyle gözaltına alındığım bana bildirildi. Yaptığım neredeyse benim tüm haberler suç kapsamında değerlendiriliyor. Hala hakkında süren 3 tane dava var. Bir tane de ifade vermişliğim var. Onun sonucu ne olacak henüz bilmiyoruz. Yani son özellikle 5 yılda 40'tan fazla emniyete gittim, ifade verdim. 2019 yılında yine bir gözaltım var. Bunu da anlatayım. Van Sanat Sokağı'nda HDP tarafından gerçekleştirilen bir eylemi izlediğim sırada fotoğraf çekmeme müsait engel olan polislerle aramda yaşanan bir tartışma ve Sanat Sokağı'nda herkesin gözünde darp edildim. Ters kelepçeyle gözaltına alındım. Ama sonradan polise mukavemet etmek suçundan ötürü yargılandım. Yaklaşık 1-1,5 yıl süren bir mahkemenin ardından da beraat ettim. Hakkımızdaki davalar devam ediyor. Biz haberlerimizi yapmaya devam edeceğiz.
İktidar internetle olan savaşını kesintisiz bir şekilde sürdürürken Türkiye'nin internet özgürlüğünün gidişatı son derece kaygı verici boyutlara ulaştı. Dünyanın en büyük internet ansiklopedisine ulusal güvenlik gerekçesiyle uygulanan sansür 2 yıl 8 ayın ardından 2020 yılında son bulurken Türkiye Wikipedia'yı sansürleyen dünyadaki 3 ülkeden biri olarak tarihe geçti. Cumhurbaşkanı Erdoğan her fırsatta sosyal medyayı hedefe alırken ülkede yüz binlerce sitenin yasaklanmasını sağlayan 5651 sayılı kanun güncellendi. 2020 yılının Ekim ayında yürürlüğe giren sosyal medyaya sansür düzenlemesinin ardından sosyal medya platformlarına yönelik yaptırımların devreye girmesiyle YouTube, Facebook ve Twitter gibi büyük sosyal medya platformları iktidara boyun eğdi. Bu durum sosyal medya platformlarının hükümetin sansür taleplerine uyumlarını arttırmak zorunda kalabilecekleri yönündeki endişeleri de arttırdı. İlgili yasal düzenlemenin basın özgürlüğünü nasıl etkilediğine ilişkin bir rapor hazırlayan Medya Araştırmaları Derneği'nin incelediği sansürlenen 658 haber arasında ilk sırada 336 içerikle yolsuzluk ve usulsüzlük, ikinci sırada ise 308 içerikle görevin kötüye kullanılması konuları yer aldı. En çok sansür talebinde bulunanlar ise iş insanı unvanını taşıyan kişiler, bakanlar ve üst düzey bürokratlar oldu. Hal böyleyken iktidar söz konusu düzenlemenin üzerinden bir yıl geçmeden dezenformasyonla mücadele adı altında yeni bir sansür düzenlemesinin hazırlıklarına girişti bile. İfade Özgürlüğü Derneği'nin verilerine göre 2015 yılında erişime engellenen internet sitesi sayısı 80 bin iken bu sayı 2021'in hemen başında yaklaşık 5 kat artarak 467 bine ulaştı. Ayrıca 150 bin URL adresi, 7500 Twitter hesabı, 50 bin tweet, 12 bin YouTube videosu, 8 bin Facebook içeriği, 6800 Instagram gönderisi de sansürlendi. Kamu düzeni, milli güvenlik, hakaret, kişilik haklarının ihlali gibi gerekçelerle başta ifade ve basın özgürlüğü olmak üzere temel haklar kopyala yapıştır kararlarla kullanılamaz hale getirilirken sosyal medya kullanıcıları yine soruşturma ve davaların hedefi oldu. Bu tablo 2021'de daha da vahim boyutlara ulaşarak sürdü. Orman yangını, sel felaketi, ekonomik kriz, sınır ötesi askeri harekatlar, yolsuzluk ve salgın gibi birçok olayın ardından iktidarın ilk icraatı sosyal medya uygulamalarını kısıtlamak ve sosyal medya paylaşımlarıyla ilgili operasyon başlatmak oldu. İçişleri Bakanlığı'nın verilerine göre sosyal medya operasyonlarında 8 ayda 39.601 kişi hakkında işlem başlatıldı, 1175 kişi gözaltına alındı, 52 kişi de tutuklandı. Yıl boyunca 64 internet haber sitesi kapatıldı, 1460 haber ve 160 sosyal medya içeriğine erişim engeli kararı verildi. Sulh ceza hakimlikleri eliyle sistematik ve düzenli bir şekilde asma kalıp gerekçeler ve kopyala yapıştır kararlarla getirilen erişim engelleri her türlü farklı düşünceyi, ifadeyi ve eleştiriyi susturmak için kullanılırken erişim yasakları da adeta zincirleme yasak tamlamasına dönüştü. Yasaklamalarda sınır tanımayan sulh ceza hakimlikleri, yüksek bürokratların maaşlarıyla ilgili haberleri, Cumhurbaşkanlığının kurumsal itibarını zedeleyebilecek nitelikte olduğu iddiasıyla, Diyanet'in uygun görmediği siteleri İslam dininin temel nitelikleri açısından sakıncalı diyerek erişimi engelledi. Meclis tutanakları, İnsan Hakları Mahkemesi kararları, belediyelerin faaliyet raporları, üniversite mülakatının sonuç listesi bile yasakların hedefi oldu. Türkiye, Freedom House'un raporlarında 2016 yılından bu yana interneti özgür olmayan ülkeler kategorisinde yer almaya devam ediyor.
Medya Araştırmaları Derneği olarak bir rapor hazırladık. Biz özellikle neye baktık? Bu erişim engellemesi kararlarına, içerik kaldırma kararlarına baktık. Ve 36 farklı yayın organıyla bağ kurarak bu 36 farklı yayın organına ulaştırılan yayın kaldırma kararlarını toparladık ve bunları kendi içine tasnif de ettik. Orada enteresan veriler ortaya çıktı. O bir yıl içerisinde 1197 haberle ilgili kaldırma kararının geldiğini öğrenebildik. Tabii şunu da bir parantez açmak istiyorum. Bu 36 mecra büyük ölçüde ulusal mecralar. Cumhuriyet Gazetesi'nden Bir Güne, Evrensel'e, Oda TV'den 9-8 Haber'e, Sputnik'ten T24'e, Biyanet'e gibi epey farklı sayılabilir. Ama bu tip sansür girişimlerinde hedefi durumunda olan mecralara baktık. Sağ olsunlar bizlerle bu verileri paylaştılar. Kapsamlı bir rapor ortaya çıktı. 1197 içerik kaldırma kararı ulaşmış bu 36 mecraya. Bunların 675'i yolsuzluk ve usulsüzlük haberleriyle ilgili, 466'sı da görevi kötü kullanma haberleriyle ilgili olmuş. 169 haber iş insanlarından gelen talep doğrultusunda yayından kaldırılmak durumunda kalmış. 102 haber üst düzey bürokratların talebiyle, 100 haberde ticari şirketlerin talebiyle yayından kaldırılmak zorunda kalmış. Tabii öne sürülen gerekçeler de enteresan. Özellikle birisi çok öne çıkıyor. O da kişilik haklarının ihlal edilmesi. 1080 haberle ilgili öne sürülen gerekçe bu olmuş. Neredeyse tümüne yakın diyebileceğimiz bir sayı bu. Ve özel hayatın gizliliği gibi argümanlar öne sürerek açıkçası bu yasanın tam da yasa koyucular, yöneticiler, toplumun yönetici kesimleri, iş insanları, üst düzey bürokratların elinde kendilerini haber yapma hakkı karşısında savunabilmelerinin bir kalkanı haline getirilmiş. Bu gerçeği bu verilere baktığımızda görüyoruz ki bu yasa çıkma hazırlığı söz konusu olduğunda yapılan uyarılar da bu yöndeydi. Her benzer yasada olduğu gibi elbette bunu herhangi bir hak kısıtlaması olmayacak. Aksine bir düzenleme ve işte yurttaşların, vatandaşların haklarını koruyacak bir düzenleme olarak sunmalarına rağmen haklarını korudukları kesimlerin daha ziyade yönetici elitler olduğu gerçeğiyle de buraya baktığımızda karşılaşıyoruz.
Teknoloji dünyayı o kadar hızla değiştiriyor ki bir gün doğru sandığımız bir şey ertesi gün yanlışa dönüşebiliyor. Aslında askeri amaçlarla başlatılan, sonra bilim alanında veri alışverişi için kullanılan internet çağımıza damgasını vuran bir olgu haline geldi. İyi ki de geldi. Eskiden ciltlerle kağıttan oluşan bilgi yığınağımız ansiklopedilere artık bir tık uzaklıktayız. Ama aynı zamanda doğru bilgiyle aramızda zaman zaman hala dağlar olabiliyor. Nasıl çözülecek bu sorunlar?
Tekrardan merhaba. Herkese merhaba.
Hello again. Hello everyone. We are on the second day of the Istanbul Gathering for Freedom of Expression. And in this panel now, we will be discussing the topics: access to information, the media, and social media. I am Yaman Akdeniz. I work at Bilgi University, and we have Sibel Güneş from the Association of Turkish Journalists, Faruk Bildirici Media Ombudsman, Gökhan Durmuş from the Union of Turkish Journalists, Fatma Demirel from P24, Nadire Mater from Biyanet, and finally, Veysel Ok from the Media and Law Studies Association. Before giving the floor to our speakers, I would like to assess the situation briefly. Well, everyone knows that the media and social media are under repression. And now a new draft law has been sent to the parliament. Not only is the press law being radically changed, but the internet law and the law of communications are also being amended. Hence, we will be discussing these changes on this panel, and you probably would have questions concerning this draft law. Of course, the first question that we will discuss is that internet journalism is brought within the scope of the press law, and we will discuss what kind of reflections this would have on internet journalism and what kind of impact a new crime is being instituted, what is called a disinformation, the crime of disinformation. This is, of course, very topical, so we will discuss this at length. Saying hello to the panelists, I would also like to move over to Sibel Güneş from the Association of Turkish Journalists. Sibel Güneş, would you assess the situation at present, and with the new draft law, how do you think internet journalism will be affected?
Mr. Yaman, thank you. This is the 13th gathering in Istanbul for freedom of expression, and I'm extremely delighted to be here with you. I would like to greet each and every one of you. Of course, regarding the current situation, we have never seen a well-being phase in terms of the situation in our country, and maybe what we are going through now is the most severe that we have ever seen. Most seasoned and experienced journalists define the current situation as such. So let's take stock of things now. We have 67 journalists murdered in this country. What does this mean? This means that practicing the profession of journalism in this country is a risky initiative, a risky enterprise. Still, thousands of journalists are very willing to practice this profession. We have a strong background and experience of this. So, the 67th journalist that was murdered is Güngör Arslan, and the public opinion is not informed about his case. Everything is closed and behind doors. Some politicians are involved, that is the allegation, as the lawyers of the family are criticizing they're not able to get their hands on enough information. And this is a very recent case, by the way. In the mainstream media, we also see that journalists, reporters, and cameramen are attacked because there is impunity, and it's mainly the politicians that are targeting, showing the journalists as targets. Many politicians serving at the parliament, the party leaders are actually leading this. And generally, those who attacked our colleagues, although sometimes they're taken under custody, as they are members of certain political parties, they are released very soon. The second issue is unemployment. Hundreds of media outlets were closed by the government. We have so many people, so many journalists that are now unemployed, and it's a consistent effort of the government to eradicate this profession. And despite this heavy condition, we have more than 800 journalists in jail in Turkey. And as the government is controlling 90% of the media, this is even not enough for them, because the remaining 10%, the independent media, are fulfilling their duties so successfully that, and the news are spreading on social media so fast that the government and the ruling party is very disturbed by this. They don't think that this control over 90% of the media is not enough for them. And other media outlets that are converted into pro-government ones, their circulation rates are going down immediately, and they are losing readers. So the ruling party is now desperately trying to control all channels as we are approaching the elections. Press cards are very important for us as we cover the news of demonstrations, because sometimes it's the journalists that are caught in between the police and the protesters. For them to be able to continue their work and not to be taken under custody, it's important to be able to show their press cards. But the presidency of communication of the presidency of the republic is using this as an oppression method. The press cards of thousands of journalists have been cancelled, and we have yet another more than 1,000 journalists that are under scrutiny, so to speak, or suspended. So there is a lot of unlawfulness happening here. So the approach of the ruling party is first to cancel the press cards of the journalists before they are taken into custody. And once they are in jail, they claim that there are no journalists in jail because they don't have the press cards. So the president of our union is here. So Gökhan Biçici is with us. I'm sure he will share the details with you, but unionization rate for the country is 13.7%. And as journalists, we are even lagging behind that. I think the up-to-date figure is 7%. Correct me if I'm wrong, Gökhan Biçici. And receiving advertising from institutions is banned for independent media outlets. And because of the labor law for press, our colleagues are forced to work with different laws. And because when we don't have security, job security, then the right to get information for people is also damaged. So journalists are trying to practice their professions under harsh challenges and difficulties, and they are receiving salaries amount to the salaries at the threshold of poverty. And advertising for independent media outlets are now banned. This also further damages the likelihood of our journalist colleagues to get their salaries. We have the Supreme Board of Media and Communications. They are continuing the crackdown on media outlets. And Mr. Yaman talked about it in his introductory remarks. The law on amending the press law and other laws was submitted to the Parliament on the 26th of May, and no opinion was received from any media organization or press organization at all. Months before, we were not able to get our hands on the draft law, but we had a joint meeting with our sister organizations, and we asked for not including the journalism activity in this law. Unfortunately, that wasn't the case. Last week, on Wednesday, the Parliamentary Committee on Digital Media meeting took place, and we participated as a Turkish Journalist Association with the representation of our Ankara representative. And the government AK Party and MHP are very determined to pass this law, as we witnessed during the parliamentary committee meeting. They think they have taken a huge step in terms of press freedom. So it was a dream, but it came true. Now they are defining the situation as internet or online media can now receive press cards. But this draft law was prepared before without getting the opinion of the journalists. So it's a very good law in terms of hiding the truth from the citizens. They have really worked well on how to limit each and every field of freedom. So Justice and Development Party and the Nationalist Movement Party MPs have really worked hard to totally eradicate the right to have access to information of people. So free circulation of news will no longer be there. Censorship will further increase, and the number of journalists facing trials or in jail will increase. And then we also have the Information Technology and Communication Authority that has seen an increase in their duties and authorities. And the rationale for this law is very interesting, actually, where there are different items. Fundamental rights and freedoms that we see in the real world will now be transferred to the digital world, they say. That's what they claim. So even the reason or the rationale for this law is ridiculous, because something that's not happening in real life, how can it happen in the virtual life? And generally speaking, the press card being included in the framework of this law is problematic in itself. When they were preparing the draft law, the MHP MP, he said this was a bundle law having an impact on 22 different other pieces of law. We will see how serious and grave the implications will be once it's enacted. But our aim here is not to identify the procedures for the press law. So any online website, if they want, they will issue a declaration. If they don't want, they won't do it. So inequality between the equals. This is what's going to happen. Then this is also anti-constitutional. If the owner of the website, if they want, they will be able to get press cards and be subject to the press labor law. If they don't want, they won't get it. Another very interesting thing or weird thing is that for periodicals, if there is a sanction to be provided, the punishment is aggravated. If there is a problem with the online website, then the press cards of the journalists will be cancelled. Another stick that will be presented to the Presidency of Communication. So as the websites are becoming more powerful, this will be another instrument of oppression for self-censorship for online journalists. And individuality of crime will no longer be there. They will be arbitrarily canceling the press cards. We will see if the journalists writing about the truth will be able to exercise their professions or not. And then the Press Advertising Board is another institution that will have yet another stick. They will be the authority now in charge if there is missing information in the declarations, and then they will be able to apply to the courts of first instance. So websites, it's very expensive nowadays to sustain websites because FX rates are increasing, and they are asked to keep the information available for 2 years. On the committee, parliamentary committee, we provided our opinion that this should be limited to 6 months, again, to increase the pressure on journalists. The period for litigation starts once the crime is notified. For instance, our journalist colleagues can be tried again and again for news covered in the past. And for every content, every update, has to be mentioned so that it won't change every time it's published. So the host of the website has to do it, but the colleagues we talked to say that it's very difficult. And then to get rid of this heavy censorship, of course, the servers will belong to foreign countries. They will get the hosting services from abroad, but then this will also impact the salaries of the employees. And Article 29 talks about creating panic and fear among people. So anytime they don't like any news, the journalists will face prison time of 1 to 3 years. We wanted this draft law to be withdrawn, but who will decide? We asked them. At the parliamentary committee also we asked them. They said it's the courts that will decide. Nowadays, trust to the judicial system. We know how it is in Turkey. Certain cases on certain topics are always yielding to certain results. We know that the courts give certain decisions on certain issues. So there will be very fast judgments and rulings made by the courts. Charges will be pressed and our colleagues will be taken in custody and further arrested. So one MP in the parliamentary committee said the following. They said, if the opposition leader of party A, when they broadcast their video, and when we cover the news of this, when we broadcast this, if the ruling party wants, we will be sued because of this. If the leader of the opposition party, if they posted this on their own social media account, then a court order will go to the social media outlet that publishes this, and they will be asked for restriction. If the social media outlet doesn't do it, they will be facing millions of dollars of sanctions, fees, and also their bandwidth will be impacted. So this is what they are trying to impose upon us. Everyone using the social media and internet will be impacted by this law. And next week on Thursday, this strange law will come to the Justice Committee of the Parliament, and we will share our opinion. I hope they will take a step back, especially about the Article 29. Maybe they will make it more flexible, but what I can observe is that they are very, very determined in that. And before the elections, they want to pass this law from the parliament. They are really determined to do this. So we, as the professional organizations, as the Turkish Journalists Association, we want to make sure that our colleagues' rights and the rights of the citizens, the people out on the street, will be defended, and we'll do our best to do this. Thank you very much for this opportunity.
Thank you very much, Sibel Güneş. It's impossible not to share your opinion. On the other hand, as you said, even the point of departure was very problematic. And then on top of this pessimistic situation, you summarized all the new sanctions and the powers that are given to repressive forces. And even if the internet journalism is included in the press law, and that seems to be an advantage, now there are new sanctions against media outlets, and many media outlets are already in trouble with blocking news, etc. There will be new threats against them. That is to say, a news article that you publish today will perhaps be blocked for access in 24 hours, but also a kind of refutation will be published because of this. And for 1 week, this kind of refutation will be on your website. We shared some news that were blocked this is tragic comic because there is Akın Gürlek, who is the judge who was recently appointed to the Ministry of Justice, and now the news made about him is now being blocked. I will give the floor to him in a moment. Sibel Hanım, I agree with you that no professional organization was consulted in this process. We only knew that this was coming, but we didn't know the details. And probably Parliament will pass this law before the end of July. It'll be in the General Assembly pretty soon after having passed the committees. Gökhan Bey, now I turn to you. From the point of view of the Union of Journalists of Turkey, how do you assess this already existing situation and the new draft law? And you were in Ankara, I think. And can I ask you in particular what the impact will be on internet journalism? Hello, everyone, both the panelists and the audience. Thank you for giving us this opportunity. In Turkey, the media has been under repression for a long time. Since between 2002 and 2006, there was a period of rather freer atmosphere, but since 2006, that is to say, for 16 years now, we have been under pressure. There was the KCK Ergenekon arrest, group arrest in 2009. Then, of course, all the arrests on remand in 2016, and then the operations of changing the ownership of different media groups. Well, finally, there was nothing left to do. Now it's this law, and they put everything in that omnibus law, and there will be no journalism in this country from now on. Why do we say this? Let me start out by saying the following. For long years now, journalists have been under pressure and looking for a solution. The fact that internet journalism developed so rapidly in Turkey is a result of this. Those journalists who were laid off as a result of this established this certain media outlets on the internet in order to practice their profession. When we look at the number of readers, we can see easily that on the internet, the number of readers are much higher. On the other hand, there is a very high level of unemployment in our industry, much higher than the average in Turkey. It's close to 30%. And many of these have found their solution on the internet. They're not counted as journalists, but they're trying to practice their profession. When this draft law was being prepared, it is said that the journalists who are working on the internet, they will be considered as journalists now. They will receive their press cards. We will even give them commercials. Well, of course, the preparations had been made for some time. And some people say to me, because I'm the president of the union, well, President, we can now receive press cards. Isn't that good? But when we look at the general situation, since 2015, we have had this communications agency Fahrettin Altun, who's the president of this agency, is doing everything possible to make it impossible to not to let journalism function in Turkey. He is going to give out these press cards. The press advertisement agency was established in the early years of the Republic so that there would be no politics mixed in this distribution of these commercials or adverts in the press. Well, Fahrettin Altun himself is very busy, obviously, and so they made a division of labor. When there are powers given to the press advertisement agency, it works like this. In Tekirdağ, say a province in the west of Turkey, they publish and they have an internet media outlet. So all the information will be brought together in a pool, and this will be under the umbrella of the press advertisement agency. Only one court will be powered to accept the appeals, the challenges to the decisions of the agency. Within 15 days, you have to go to the court. These internet websites who are doing their best to both manage journalists and also look after all the problems of internet journalism will come from, distant provinces all the way to Istanbul to solve their problems. Internet sites, websites, well, any piece of news usually remain on the website for only 5 or 6 hours, but the disclaimer or refutation texts will be put on the website in 24 hours and remain there for 1 week. And the appeals can be made to one court only. Let's say, again, distant province like Hatay had this problem. There is a refutation document at 10 o'clock, let's say. It has to publish this in 24 hours. In order to challenge this decision, it will have to come, the director or the representative will have to fly to Istanbul and then try to get the decision not to publish the refutation. Well, in the print versions of newspapers, there are 3 days in which the newspaper can challenge the decision. But for internet websites, this is only 1 day, 24 hours. So this is the kind of law that they have prepared. And they say we will give out press cards to journalists working in the digital world. Yes, okay, they will, but it brings about the following also. I have 10 employees, but I did not really declare these employees, or I did not go along with the decisions of the press advertisement agency. It's me who is guilty, but the press cards of the employees that are cancelled. We know that the pie has really grown smaller and smaller, out of which the commercials, the advertisements are distributed. So there is, all kinds of problems here. Now, last week we were in Ankara, and we talked to the group party group whips. Generally in the talks we had with these whips, I have the following impression. Well, with respect in particular to Article 29, well, this is too much, people say. Everything will really be totally under control. Apart from Mahir Ünal, who is the whip of the AKP, the Erdogan's party, there was no one who really defended Article 29 to the last ditch. But Mahir Ünal has not signed the draft law.
Hukukçular daha iyi bilirler. Veysel burada, Yaman hocam.
Jurists know this better. Veysel is here and Yaman Akdeniz is here. You know this better. There are very uncertain expressions, to make the people believe in fake news, things of that sort. Detail that I dwell on a lot, not very many people dwell on it. This is provoking people into an organized uprising. For instance, our economy is deteriorating. An economist is, giving a kind of, declaration to the press, and the dollar will go up to 30 lira in a month's time. And when newspapers or media publish this, this is an organized act when they do this together. Secondly, with respect to adverse developments in Turkey, and people, especially in Twitter, use the same messages over and over in their tweets, and this could also be considered to be organized. So we should not, this should not escape us. In the commission, all the articles were discussed, and there's no change. And next week also in the other commission, there are certain signs about Article 29 being changed and some other provisions as well. Well, 1.5 years ago, the rate at which journalists grow old, and get tired and exhausted with age, this is now put into the press card, into the nature of the press card. This is like depreciation of a machine for the human being. We don't know what term should be used in English. So we should be very careful. I'm interrupting you, Gökhan. I would like to ask you and Sibel Güneş together, and I'll be asking this to Veysel as well, which media outlets on the internet will be subjected to this law? And secondly, news sites such as Deutsche Welle Turkish or the Voice of America's Turkish, these kinds of sites, what is their position vis-a-vis this law? Thirdly, the Media and Law Studies Association website or Faruk Bildirici's websites? Are these or our website, are we going to be to come within the scope of this law? And what happens when the law passes? I see a problem there as well. First, I would like to hear your assessment, and then Sibel Hanım's assessment. Well, this is how this is marketed. We are going to give you commercials, advertisement, and press cards. Well, internet website media outlets go and make an application. What if they don't? What happens? I don't know if there's anything behind this, but there is no preparation that one can visible in the text of the law, draft law. What is the position of journalists who work for that kind of media outlet? So it's really floating in air. They brought this after having discussed this for 2 years, and this is strange. No, because this is a fundamental question. If they're not subject to the press law, then you don't have to publish the refutations. So it's not only the press card or commercials that go by the board, but also you don't have to abide by them.
Well, Mr. Yaman, previously they tried to have a legislative effort for internet. This was in the committee, parliamentary committee, and we were invited as the Turkish Journalists Association. It was 6-7 years ago when Bülent Arınç was the deputy prime minister. And at that time they said, there was again a similar draft law, and at that time they said, those who want can apply for it, those who don't, won't. And here, the advertising aspect is the carrot. So for long years they have been discussing this, but the sad thing is that professions with internet in their name said this is a wonderful piece of law. At the committee, parliamentary committee, they praised the success of this draft law at that time. And there were people who were extremely satisfied about these things that we are talking about today. It's like people getting on the airplane of the president. And I won't give any names, but previously those people were saying that they're not getting the internet journalists on board of the plane of the president. I won't give the name, but he was the president of one of these associations, member of us as well. So our association, because of the complaints against that person, removed him from membership. But what's happening here is that if they give advertising, they will declare it. And we can use the advertising or advertisements as for censorship purposes, and then the journalist's press card can be cancelled. That's what they told, I think. So this is such a hollow and not well thought of draft law, just for the sake of getting the money for advertisements. They think they will make the declaration. So it seems as if they really believe in this, that the journalists will do this, but there is a gap. There is a loophole here. Those who don't do it, what will happen to them? It seems as if there will be arbitrary treatment against them. I'm talking about real journalists. So the pro-government media is like a choir of the government. So they have the single type journalism or journalist model. There are many websites, news websites that conduct journalism in such a manner. So they just cover the news in the way the government wants. So those outlets also had their representatives in the committee, and they didn't feel disturbed about it at all. Just to get some extra advertisements, they emphasize certain details. But unfortunately, there is a certain darkness here. Faruk Bey, I'll give the floor to you.
Faruk Bildirici. Well, as I can see, as far as I can see, there is a concept to win the quality of a news site. So these those sites that apply for recognition win that character, and they receive adverts, and the people working for that website receive press cards. The others lose that quality. But there is no legal arrangement as to what happens to those sites that do not win that quality. They will not win the quality. And even if they're journalists, the employees cannot receive press cards and no adverts. But in the political environment in which we live, there may be some website media outlets that will not go for this law. Well, what happens when there is a refutation document? Will they be able to say, well, probably there will probably be something like, these media outlets cannot do journalism. Well, this is the door that has been opened, and we can really guess what will happen later, foresee what will happen later. So this should be refused in toto. This cannot be rectified or reformed. And one should not forget that, and you know the details much better, all of you. It's not that easy to receive adverts from the agency. Even newspapers like Cumhuriyet, Bir Gün, Evrensel, which have been around for tens of years, cannot receive their share. And then there are submissions to the Constitutional Court. And with respect to the amendments of 2020, the CHP, the second party, the first opposition party, had challenged the law, but the results have not come yet. And there's a pilot decision. That pilot decision has not been assessed by Parliament or has not become a part of Parliament. I don't think they will bring this in, but we are face to face with this situation. Now, Veysel, hello. Well, let me ask you this other aspect. Well, you're the Media Laws and Law Studies Association. You do a lot of news production, and you warn public opinion. You report on many things. You follow cases, and you do both. You have publication. You publish both in English and Turkish, and this is not perhaps daily journalism, but it is a permanent flow of news items. And of course, Şener Yurdatapan has his own website. What kind of impact will this have on that kind of website? Let me ask this. Well, secondly, let's go into the details of this 217A, fake news, the spreading of fake news. Yes, Professor Akdeniz, Sibel Güneş and Gökhan Durmuş explained everything. I don't have much to say, but I will answer your questions. This draft law will have an impact on civil society as much as it will have an impact on journalism. well, we as the MLSA monitor cases, publish reports on this or other matters, and we use scientific data and publish this in reports. The new law will call these disinformation and spreading fake news towards the people, and will be prosecuted. From NGOs that research on torture to all kinds of websites that publish information on many things, they will also suffer from this law. This is, yes, of course, this targets journalism, but also it really targets as well civil society organizations, because we are following freedom of expression cases or monitoring these cases, and we send the reports to international bodies, and we also send them to certain interlocutors. Now, these reports will probably be considered reports or works that really mislead people. That is to say, disinformation. Let's say the Human Rights Association publishes reports on torture. They will be considered as disinformation as well. And the government, therefore, does not want to let any information apart from that information approved by itself to spread. So I have no idea whether we're subject to this law or not. Whether we come within the scope of this law or not, because there is no such provision. Because it leaves optional whether you submit an application to being part of this law, but the internet media close to the AKP and the government have been waiting for this. They have been trying to bring about this kind of situation for years now. Of course, we are for internet media outlet to be recognized by law, but this is not the way to do it. So these internet media, which are close to the government, will receive adverts and therefore a lot of money. I was a lawyer for a newspaper for long years. 70% of the cases I took over were about refutations, disclaimers. And therefore, these media outlets will need legal assistance. There are many different technical aspects to this, and they will be under judicial pressure, and also they will face the question of where to publish the disclaimers. We will see disclaimers on the first page of the main page of the websites. Last week, Kemal Kılıçdaroğlu talked about a case of corruption. A lot of money was being sent to the United States from Ankara. He wrote about this, he shot a video of him talking and spread this from his Twitter address. Even this could be considered to be disinformation, fake news, and therefore could be prosecuted. The government does not want this kind of news to spread. And then there's another provision that says that In extraordinary situation, there will be meetings with social media outlets with respect to public order or question problems for public health, etc. Now, what is this? I mean, is it a kind of natural disaster that's happening, let's say wildfires, and all the social media come together with the government? What is this? So when this law is adopted, the spread of news that government doesn't like will be blocked. No corruption reporting will be permitted. No peace on the policies in Syria, government policy in Syria will be permitted. Veysel, I think you're frozen. I think he's dropped. No, it's not. Yes, Veysel Ok has connection problems. Well, Veysel will continue when he comes back. I was going to say the following. Although I agree with what Veysel says, if even us jurists don't understand this law, there is a problem with it. I say this to journalists. It is not easy to assess this draft law within the legal framework. Well, the disinformation Article 217A, the disinformation provision, this is something that cannot be implemented, it seems, because it's characterized as danger crime, and to create worry, panic, fear among the people. How do you define these? It has to do with the general health of society, public health. It has to do with internal, domestic and international relations of the country. I was telling our colleagues here that if even we jurists do not understand this law, then this law is very problematic. On the other hand, there's, it has to really violate public peace. Well, someone will write a piece and then people will go out on the streets, or a tweet will be sent and people will revolt. This is not very possible. But on paper, this will remain on paper. But in practice, will it be so? If they have a provision, they have inserted that provision there, then it should not remain on paper. The spreading of the news, they have to be clear on what kind of damage this creates on the community, the society. There's nothing about this in the draft law. So there should be certain criteria within the jurisprudence. There is nothing in the law. Is it just the fact that the news is harmful, or should it have an impact, a real impact on the society? A judge, if the judge says this is against public health and public order, this will be sufficient. Well, I was giving you an example of a wild fire. We saw on Twitter that the fire was going on in Bodrum when the government said it had been extinguished. Now, this is not an AKP-CHP conflict. Whatever environmental problem there is, if the government does not want it to be heard, or corruption or whatever, the spreading of information will be obstructed, because there is no legal criterion in the draft law. In the draft law, there is no probable occurrence, whatever. And this will, perhaps we will understand better, perhaps, the law, but we will be victimized. And those that have websites from abroad, they are probably under risk too. There's nothing in the law, but the scope may be widened in the last final draft. One final question, Veysel. When we assess all this together, in the medium term, will certain media outlets, digital media outlets, be shut down? There is no clear guidelines with respect to how these media outlets will be treated. Well, you know, you have not really submitted as a news website, therefore you cannot do journalism. Perhaps they will say this, I don't know. But both on social media and with respect to news spreading, there will be a lot of censoring. There will be, Nadire Mater is here already. I would like to ask the same question first to Bianet and then to P24. How do you assess this law? What will happen to P24? Will you become come into the scope of this law? Will there be new sanctions? How will you be impacted? I know that Bianet has had many obstruction of publication for news it has made, and Bianet and P24 will both be impacted. Even for us, the Freedom of Expression Association has received this kind of blocking of news once or twice every month. And we, of course, appeal against these, but no one listens to us. And then we go to the Constitutional Court. Well, are you going to go into the scope of the draft law? Are we going to go into the scope? Nadire Mater, your turn.
Thank you so much. I'm so sorry. I had some connection problems. I wasn't able to join. And I was just thinking, because of that, when we don't have internet, we feel desperate. I was just thinking, we used to cover news in such harsh conditions, but I was just calling Şener and I was just telling him I'm not able to participate because of this. I just learned one thing, which I really liked. This is like we are actually giving up in comfort. So first of all, I would like to thank Şener and all of you, because even discussing these issues is very difficult. We cannot create environments to discuss these topics. So this gathering has really been very good, and I hope it will continue. So I was able to follow the discussions from the middle of the speech of Gökhan. I think there is a lot of legal issues that is being discussed. But let me take on from a different perspective. Without law and legislation, I'll talk about. I had so many things, but I don't have my computer with me now, so I don't have access to my notes. I'm in a friend's house. So what does this draft law tell me? What does it mean for Biyanet or journalists? One is the issue of press cards. Second one is the issue of press advertising agency. It was mentioned we have two carrots. This created excitement for the journalists, and I'm really shocked to see that. That's one thing. Blocking access is another issue, and then Article 29. I think the most important of all here is Article 29. We have to discuss this. And when we are discussing this, it says creating panic, right? So I'll take a reverse approach and I'll say, I don't think there is any panic created among the journalists because of this new legislation initiative. So this comfortable submission, this is a term that I recently learned, this comfortable submission or submission in comfort. I don't want to give away to that, but there is a submission here. We had to discuss this draft law before, but we weren't able to do this. And that's why this meeting is very important. I think the Turkish Journalists Association was also working on this, and the union, of course, was working on it definitely. So what is it changing? That's the question. This draft law, first of all, let's talk about this blocking of access issue. Blocking access. When it happens, we really face it in silence and very calmly. Every time there is a blocking order, we try to bring it to the courts. But I think last year in August, 140 blocking decisions came, and I wasn't even able to follow that. Meriç Eyüboğlu, what did they do about it? I don't know if they brought it to the court or not. We're so confused. You're talking about that list, right? Long list, yes. So this is like an impossible banning or blockage, but we weren't able to cope with it. And we think it's normal. So Faruk is with us. He used to write his column in Hürriyet Daily. Every time he was following up on the numbers. Now we're not able to follow it at all. And the government is not announcing it. Oh, there is a blocking of access decision, people say. Most recently, Bülent Şık's article on food and pollens, we received a notification from the pollen company. When we read it first, we thought it was coming from the Union of Blocking of Access. No, it's not the case. They wrote it themselves. The company wrote it as if they're instructing us to remove that content. So that is the level that we have reached now. So why haven't been able to share these things and discuss these things so far extensively? I don't know what the other colleagues will say to this, but this issue of remove my content, removal of content, this atmosphere of fear created in Turkey, quote unquote, is something that really makes one desperate. And you fall in despair because of this. So many things have been written. Sometimes I remember it gets a delay to publish it. And people get back to us, why didn't my text get published? And now they are writing, just publish my text. They say, for instance, they made a statement on the 6th of November about the Council of Higher Education, and now they think I can't find a job. What do you mean? Removal of their own content? Yes, yes. There are people who want to get their own articles removed. For instance, people who have signed certain petitions, they say, remove me, remove my name on from the list. Sometimes we do it without giving the names. We say, on this date, on such and such date, one person asked for the removal of their signature from the list. For instance, we say we have 888 people who signed this list petition. Now one less, we say. So people ask for the removal of their own content. So Article 29, that was something you were discussing a while ago. It says misinformation, misleading information. What is misinformation? It says public peace. What is public peace? How do you define public peace? It says concern, worry, panic. How will we define all these things? So as journalists, we need to bring these up on the agenda. I don't know if anyone is doing it, but we haven't done it as well. So how are we going to proceed with this? So I don't know what you will say as lawyers, but what I'll say is the following. The existing laws and regulations already give them the chance to do all the things that are foreseen in the new law. So why are they bringing this new draft law? So when I think about it, I think maybe it's just to further intimidate us. I think they're trying to do this. We will be intimidated and we will start thinking, okay, let me not do this, let me not write that. One of the most important hot topics in Turkey currently is this. For instance, an incident that is conducive to distorting public peace is the statements of the president. He called men and women bitches, right? What else did he say? Rotten bitches. Yes, he used these words, rotten bitches. He addressed citizens of Turkey as rotten bitches. And this really fits into this statement, conducive to distorting public peace, right? But they won't use it. So for him, we will be imposed actually this law because we will be objecting to this definition of rotten bitches, and then they will think we are making statements conducive to distorting public peace just because we actually objected to his statements. So we haven't been able to raise our voices. I don't know why, but I don't want to talk about the issues that I'm not knowledgeable of. And disinformation, of course, is defined by international agencies. For instance, there's a definition of OSCE or other institutions. We won't read it out loud here, but the source of this information is the governments, because they have the means of propagating this information. So how are we going to convert this in favor of us? We have to discuss this, and I really honestly don't know how we can do this. Maybe we can continue discussing from here. I don't know how many minutes I've talked. It's okay, you can talk for more. Before you took the floor, Sibel also talked about it. Of course, this is not something that is happening to us for the first time ever. We are already experienced about this, and experts' opinions are not sought for. Nobody is asking the civil society, nobody is asking the experts, and once you read the draft law, once the draft is proposed to the parliament, only you have the chance to make some cosmetic changes. You know that it will be a law very soon, with just minor changes only. So in all the amendments in July passed from the parliament within 48 hours. So the Digital Media Committee of the Parliament gathered, and I'm happy that the Turkish Journalists Association and the Journalists Union of Turkey went to the meetings. I'm surprised, and because most of the time you don't even get the chance to go there. You're not even invited, or you're invited in the last minute, so you can't go there. So such draft laws or proposals that pass from the parliament in such a short period of time never give you enough time to get prepared against them. Yes, but can I say something? Last year, 2021, September and October, this was discussed. They discussed different models, Singapore model, etc. But we could have continued our discussions based on that, but we didn't do it. Now we really have limited time, that's true. But within this limited period of time, when we ask people what they think about it, they say, oh, I haven't looked into the text yet. For instance, the issue of press cards. For instance, I want the press cards were cancelled. 3,000, 3,500 cards they're talking about. So people working in digital media, we get happy because digital media members will receive press cards, but then nobody discusses the fact that the press cards should be issued not by the government, but by the journalists' associations or organizations. So this is so sad. Nobody even thinks about this. So maybe from now on, today is Sunday, for instance, starting from today, it will go to the upper committee, right? The Justice Committee. I think at least for 1 week, it will be discussed at the Justice Committee. Let's cover the news on this, about each and every single article. Let's talk about them. Let's assess them in detail. For instance, public peace, it says, but it doesn't say national security. No, it says conducive to distorting public peace. That's the definition of dangerous crime. Yes, because we always are used to hearing the word national security, but it doesn't say so here. Yes, but it is not important what they say. As you know, in April, they changed the law number 5651 for the removal of content and blocking of access to content that distort public peace. At that time, we had the prime ministry and the relevant ministry, and then it was abolished. Now the presidency and relevant ministries are authorized to do that. So after the 7th of June 2015 elections, the first target was the dissident media outlets and the Kurdish media outlets. But in practice, it was such widely implemented that even Wikipedia was banned in Turkey for 2.5 years. We now have the media, digital media outlets, Oda TV, Genius. We are so used to it, right? Yes, we are so used to it now. So it comes one after the other. So the carrots here are now very small. Sibel and Gökhan talked about these. We know who will benefit from the carrots anyway. For you, it's the stick, right? Not the carrot. And on the other hand, you're also right. We need to continue our struggle and we need to do our duty. Süleyman Soylu most recently made a statement about the associations and the civil society. It was a long speech. And I was, well, it's so surprising that in the last 5 years, number of civil society organizations and associations have increased. Despite all these things, it increased, he says. He's surprised by that fact. So in reading between the lines, you can understand that he's surprised by the increase in number of associations. And then he links it to the fact that, oh, they are funded internationally. So, of course, we will continue our work. And let me refer the same question to someone else. Okay, I'll just say something. No, the article talks about domestic and external security of the country. It says distortion of public peace, yes, but in the article it also talks about distorting the national and international security of the country. Yes, but first it says the content has to create worry, fear, and anxiety. And then the content should be about the general situation and public health. And then it should create fear and concern. And then the third thing, it says it should be conducive to distorting public peace. So when you list all these three elements together, it's very difficult to commit this crime. However, in practice, that won't be the case. So against many people, journalists, dissidents, there will be trials, criminal proceedings, and maybe as a result, maybe most people will be acquitted, but in that long process, there will be this climate of fear that will be created. So it's a totally uncertain situation. You'll say, I didn't create panic. They'll say, oh, you created fear. Then you'll say, I didn't create fear. Then they'll say, oh, you created worry. So these are impossible to define, actually, legally speaking. Okay, Fatma, let's turn to you. Same question to you. From the perspective of P21, can you make a general assessment? Based on your website, will you be under the scope of this press law? If yes, what will happen? Especially from the point of view of digital journalism. What can you say? You are on mute, Fatma. Okay, now we can hear you. First of all, thank you, Professor. And I also would like to thank the Initiative for Freedom of Expression for organizing this gathering. Many of the things have already been mentioned by the previous speakers, so I don't want to repeat all the things, but I'll just make a summary. As P24 Independent Journalism Association, we have been working in this field since 2016 in terms of following up and reporting the cases and trials. I'll share some concrete data with you in a while. So in the field of freedom of press and media and expression, with the emergence of the state of emergency, we have seen a big deterioration. Hundreds of journalists were detained, media outlets were closed, and Turkey has become the country that has the highest number of journalists in jail. After this acute period, so to speak, the crackdown on media became systematic. It became continuous, this crackdown, and it was diversified in a way. And it's still the case. Looking at the current situation, I'll try to focus on the journalists facing trial and in prison. During the state of emergency, arrests and pre-trial detention was peaking, but now it's reduced. There are two reasons for this. Most of the journalists in the prison were arrested in 2016, but their prison time has now been concluded, so they are being released. That's one reason for the reduction of prisons or journalists in prison. And then in the last 2 years, we are not seeing any pre-trial detention. So there is the trials are ongoing without detention. So it's really, the number is really reduced. According to our data, it's 52 people, but during the state of emergency, it was at one period of time higher than 170 people. So this judicial threat against journalists is not decreasing. On the contrary, it's increasing. It's becoming more widespread and systematic, as we are witnessing. And starting from the beginning of last year, we have this quarterly reports on freedom of expression and press. Looking at the figures for the first quarter of this year, we have 60 journalists on average tried monthly, at least in one case. The last year, in the same period of time, it was 70 people. So every year, every month, we are seeing 70 journalists being tried. So new trials and new lawsuits are being filed. There are some people taken in custody. In the first quarter of this year, 7 journalists were subject to investigations, 13 subject to prosecution, and 16 of them have been in custody, mostly during the time they were exercising their professions. So trials are just one dimension. I'll just briefly pass it. Sibel also talked about it. We also have the attacks against journalists, which is a huge issue. We lost one journalist, unfortunately, this year as an armed result of an armed attack. And during demonstrations, now there are attacks seen on journalists. And during demonstrations, we also have some public demands. or some violations related to police intervention, it's now almost impossible to cover the news on this to make the public know about them. Then there is the issue of impunity, as mentioned by Sibel, and then we have the sanctions brought by the Radio and Television Supreme Council. They have issued fines of more than 250 million TL. It's always KRT, Fox TV, Halk TV, and it's always the same channels. And then we have the issue of the press advertising agency, which has now more authority with the new law. They play an important role in terms of distribution of the adverts income, but they are using this in a disproportionate manner. And then blocking of access is another issue. Removal of content decisions are there. Then your platform, Speak Up 24, you also receive some fees, right? Sanctions? Yes. For P24 also we received, retrospectively, by the way, we received 20 sanctions going all the way back to 2015. There was this link that they asked for the removal. So these are the topics that are very important in themselves, and we have to talk about them in detail. But while all this is happening, we're also discussing this new law on disinformation. The article or the issue about disinformation is not only covering the journalists and media outlets, but is actually threatening the freedom of expression of all people in Turkey, not only the journalists. From a perspective of freedom of press, then this will be a new instrument of the already existing censorship mechanism. This will be a new grounds for trying for the trials of journalists. As you know, we already have many articles of law that are used against the journalists to prosecute them, the law, the anti-terrorism law, defamation law, etc., etc. And with this, we will also have now new lawsuits that will be filed with the on grounds of disinformation. And I said the number of journalists in prison have recently declined, but this will increase the number of journalists in prison because there is a foreseen amount of prison time. You asked about the status of P24 with the new legislation. Of course, we are still analyzing the draft law in detail since it was announced, but it makes a certain definition. Written, visual, or audio content on digital platforms and periodic publications for the purpose of that, it says. P24 is not a media outlet. We are a civil society organization that has the status of an association working in fields of freedom of expression, environmental issues, wide range of activities we have, and we share with the public the output of all our activities, and we publish them on our website. Among the outputs, of course, there are certain contents that can be considered as news. So, will it include us within the framework of the draft law? Maybe yes, with this definition, yes. But as everyone said, I think the text of the law itself is not clear enough. It's very vague. So we'll have to see the implementation, and we'll see if there will be any secondary legislation that will be enacted for the implementation of the law. I think this is all I would like to say for the time being. Yes, I agree with you. When we were discussing this with Veysel, I was also thinking about this. You have the status of an association. We also, as the Association of Freedom of Expression, have the same status. And Veysel, their organization, also has the same thing. But I know that in practice, we will also receive some decisions for refutation or retraction, and then we will claim that we're not subject to the press law. So this will turn into a legal struggle, and as mentioned by Gökhan, of course, from all over Turkey, from local websites, news websites, digital websites, both technically and legally, maybe they won't be informed, they won't have the capacity, they won't have lawyers, maybe they won't have the the capability to object to the decision, or maybe there are so many decisions, court decisions, that they won't be able to cope with it. Like Fatma also said, you received retrospective decisions, and Nadir also talked about more than 120 decisions, and then there are also some access blockage due to the Turkish Penal Code. So all these open lists are published by content providers, and the news outlets are sent these lists, and there is pressure against for the removal of content, not only blocking of access, but removal of content is the main purpose here. And then there are the refutation or retraction decisions that will be issued. So fighting against this, we don't know how it will happen. We can only say that after the law is passed. Well, yes, we are subject to the existing laws already. Now we have the press law that defines organizations with periodicals. So we'll have to be subject to the press law as well, all these news outlets. And then who will be responsible? The editor-in-chief has to be appointed, and in practice, it might be difficult or maybe easier for certain people. And we have to tackle these issues. And the definition of a news website is very narrow, but maybe we have hundreds of websites that work on a copy-paste basis. You don't even know who the host is, but they share this. If they all apply, claiming that they are news websites, then what will happen? We talk about this carrot, the revenue, the income from the public adverts, but what is the amount of the revenue anyway, so that it will be distributed to all these people? So what is the amount for the digital media? So we cannot see actually the limits of this, and that's also something that is not very clear in my mind. So how many websites will be included in this as news websites? How many of them will be considered as news websites so that they will also receive some advert income? And in terms of the newspapers and the digital news sites that will be a new part of the system later on, to what extent it will be attractive?
Can I come in? The press advertisement agency had its general assembly 10 days ago because it has problems with respect to its revenue flow. They decided to sell one of the buildings that they have. Because they have administrative problems, there are problems with respect to their incomes. And the sale of the building has been submitted to a lot of criticism. Fatma Hanım said this as well. I think that resources will be diverted to those websites or those media outlets close to the government. It's not possible to satisfy all the different demands. Faruk Bildirici, now it's your turn in order to assess all that we have been discussing with respect to internet journalism. You have a website, a personal website, and you have been publishing on it. And before I came here, I looked at it. Well, you have a rich content there. And since the beginning of May, when I look at the what you have published, one can say that you have a permanent flow of pieces, and you write on topical issues. When you assess the situation, how are you going to be impacted by this new situation and people who are in a similar status? Thank you. I think this was a very useful meeting. It opened our minds. I'm trying to understand what is, in the draft law, and every time I find something new, but I've learned so much from our friends here. Thank you very much. I do a dual kind of thing. On the one hand, I write pieces as a media ombudsman. There are around 10 media outlets from Birgün to T24. I write for them every Monday. And if there are ethical problems, I establish contact with them, and that's how I proceed. Secondly, Nadire Mater reminded us when the blocking of access decisions came first, I was at Hürriyet. I published all the access blocking decisions that came to Hürriyet. This way, I drew to the attention of the reader to these. I would like to make a proposal to Nadire Mater and all the websites, news websites that exist. And I wish every internet website, news website has a page showing what is blocked, and the reader can thus see what is being blocked, and this way there is a blocking of the blocking, so to speak. Secondly, coming to the law, do we need a new law? Yes, we do. The press, this is a press law. First of all, this is really a problem because we're not the press, we're now the media. But then our law is so old that we need to bring in so many new technical aspects, voice publication, websites, etc., that we need a kind of comprehensive law. But is this the law that responds to this? No, this is not that kind of law. This is a kind of law that responds to the needs of the government. Well, the most important administrative authority was what was called RTÜK, that is to say, the Radio Television Superior Board. Now there are so many more administrative authorities that oversee our activities. Not only the press, but now internet journalism is also being brought under the authority of these. Well, the Information Technology Agency, why is it brought in? And the Communications Agency. Fahrettin Altun, why? Because Fahrettin Altun was using arbitrary measures for press card, and then some people went to court against his decisions, and many of these were won. So Fahrettin Altun understood that he could not solve this problem with the existing regulation, so this new law came about. The powers of Fahrettin Altun are now being guaranteed by law. Well, these are also administrative authorities for us, without even asking us, and they decide. The punishment comes, and then we can challenge that punishment. And when that is not possible, of course, we have to publish the disclaimer. I would like to come to the following point. These are neither agencies that have expertise, nor are they bureaucratic agencies. These are political authorities. The press advertisement agency was of that kind. Now, other authorities are becoming politicized more and more. The Radio Television Superior Board is also like that. And the communications agency has such a structure. Well, 4 people are from the outside out of the 9. There will be only cosmetically placed independent members. Well, everything that has been said by our colleagues is true. Well, one needs certain criteria, of course, and definitions, but they don't feel the need for that. Whatever instruction comes from high above, they will go along with that. Now, in the past, with respect to the press cards, we see that what is in the law is very grave. First of all, the barriers in the way of receiving a press card is increasing. But those that are not journalists are receiving press card. Well, the public servants in the communications agency, for instance, will receive press cards. They say there are more than 3,000 press cards exist, but outside of this, they're now giving out press cards to not to journalists, but to public servants, civil servants. But freelance journalists living and working outside the country will be given press card. I don't know how they will decide. Will be given cards, but this is all arbitrary, right? Well, it says media associations to be determined by the president, etc. So there is a commission of press cards. That's Fahrettin Altun and his retinue. Well, they are not giving press cards to real journalists in the process. So this arbitrary kind of practice will be turned over to Fahrettin Altun, who now has the sanction of the law for his practice. And then there is something else. Some colleagues said this. When there is fake news, the press card is cancelled. In the past, when there was, false news, there was no punishment for the journalist. Here, along with the media outlet, the journalists themselves will be punished. Well, for many years, they cannot receive a press card again. But I found something, a provision that is positive. They say, it is said that those who receive press cards cannot engage in trade. Well, this is good. Well, sometimes, this kind of thing one can find in all kinds of legislation. Then there is, of course, the press advertisement agency. It is so fortified, so strengthened. The internet, the domain of the internet, will come under its control. How are they going to cope with this? With what structure? I don't think so. They don't have the structure. What did they do? Without taking into consideration the circulation of the media that is close to the government. They feed those media outlets, but many of the opposition newspapers were punished. Well, both the Radio Television Superior Board and the advertisement agency have the same thing. They give out. Well, it's not the advertisement agency that is going to give out the advertisements. It's going to control them ethically. First of all, it's non-ethical to have an institution that has the money in their hands to do overseeing ethically. Well, in the RTÜK, that is to say, Radio Television Superior Board law, there is all the defense of the family, etc., etc. So the majority of the board of the Radio Television Superior Board will determine all this, give the judgments, ethical judgments. Well, it has been said that for a full week, the disclaimers will remain on the website. That is very grave. The advertisement agency really distributes the public publicity. This really helps the local media to survive. The physical media, that is to say, the national newspapers and magazines, will suffer from this. So this public advertisement pie is shrinking. This will also, a part of it will go to the internet now, but the real outlets that are in need are the local ones. Now, the internet news websites will be publishing these advertisements. If you want to see a publicity, let's say, from the department in the public administration, you can look at the website of the press agency, advertisement agency. So what is the point of looking at the media? And from this provision, I think the local media will be very much impacted by the fact that a new shareholder comes in the form of the internet journalists. There is the savings circular of the president, and therefore there are contractions in the pie. So local media will suffer. This Article 29, the misleading news, this is really the Damocles sword that is above us. They will use everything. But then the provision is very important. Well, it says the punishment will double when the identity of the perpetrator is kept hidden. Well, what I think Yaman Akdeniz says, are they perhaps talking about anonymous websites? Well, that's possible. They will always ask for it because there is a provision. But then the law enforcement will go to the portals. But perhaps it's the source that we are hiding that they want to uncover. Where did you receive the news? So that's what I have anxiety about. There are so many expressions that are open to interpretation. Well, one worries, really. These are very dangerous because even in our press law, the journalist has the right not to disclose their source. These are universal rights, and we have it in our law as well. The distinction between domestic and international is removed. In the past, for instance, in the encouragement to a suicide crime, they could not come in, but now the information technology can come in. There was even a repeal by the Constitutional Court on one of these powers. Now they have put that aside, and this way the decision of the Constitutional Court is ignored. They are giving these powers to the president of the Information Technology Agency. Access obstruction decisions that are taken as administrative decisions cannot be appealed against. So some of the crimes will come under catalog crimes, and then arbitrarily, on the basis of the decision of the president of the Information Technology Agency, there will be all the consequences of the catalog crime will flow. Well, at least, and when a criminal court takes the decision, we can go to the records, etc. Here, everything will be arbitrary, and this is what it seems. The union of access providers, will not be included in this either. The president of the Information Technology Agency Ibrahim Kaboğlu brought this on the agenda. As you know, he's a constitutional, he's an expert in constitutional law. Well, you said this as well. Yes, catalog crimes are all brought under the scope. For instance, the question of the MIT, that is to say, the National Intelligence Agency, writing news about the National Intelligence Agency is now prohibited, and this is brought under catalog crimes. Many websites is being obstructed because of obscenity or terrorism, etc., etc. Now they will close them down directly. We can't even learn what happened. This law, the most important aspect is, the most important aspect in this law is the social media. That is to say, the reason why it is being promoted. The media controlled by the government in power is 90%, yes, but there are two outlets that are not being controlled. One is independent internet journalism, and the other one is the social media. That is why this law is being promulgated. The critical media is, let me not discuss this, but social media is very important. The provisions there, with respect to the intelligence agency, the ban on access measures, etc. The anonymous addresses there with respect to social media and all the obstacles brought to sharing, etc. All this, if I'm not mistaken, the digital media and social networks law was promulgated only 2 years ago, and now when there is obstruction of access decision, and all this is implemented immediately. But this kind of law, I think, will give them a lot of difficulty. And when they have the difficulty, I worry that last time the international social platforms, social media giants, they had really overcome this. When while going to for the elections, they can shut those down, or they can narrow the bandwidth, and they can obstruct people from accessing those social media outlets. Twitter closed down more than 30,000 bot accounts. They were not able to dominate these big social media giants, so they target these social media. Yes, of course. We talked about the press today, but after the changes in July 2020, social media platforms, the question of their representative being here in Turkey necessarily, well, if they don't send a representative, then the bandwidth would have been narrowed down. But the shell companies that they established in Turkey, they used in order to abide by the law. Now, the decision they have to make is whether they will go under the scope of this law. There are serious sanctions, and then the sanctions are serious. Now, as we're nearing the end, let me ask one final round of assessment, and then there's another question. I will ask you this question and ask you to assess it. Do you think there is any impact of the strengthening of the opposition on the development of this kind of development of the law? May I take your view, Sibel Güneş?
Well, yes, I believe this draft law is related with the strengthening of the opposition. And then secondly, we have now the representatives of the mafia who are currently living abroad, but who are making some statements to put the ruling party in a difficult position. I think those statements are also another reason for the preparation of this draft law, because in terms of independent journalism, we have only a few TV channels who can have independent broadcasting activities, and the opposition members can never find enough space in mass media. However, they're compensating for this through the social media. I read a study about this. Those who vote for the ruling party mainly watch TV, as it seems, and those who vote for the opposition parties, especially the voters of the main opposition party, they mainly get their news from newspapers and digital media. So which accounts will be subject to this new regulation? This was asked in the committee. It will be about the anonymous accounts. They clearly stated this. The MPs of the ruling party stated this out clearly. However, I believe as we are going to have these snap elections, most probably, in terms of the crackdown we have, it's going to be a very, very difficult situation for us, both for the journalists and civil society organizations. This will be an important or a very heavy blow for us. And number of people whose freedoms are restricted will increase, because now it's reaching out to almost everyone, apart from some institutions protected by the government. Everyone is affected by this, and more people will be affected by this. Another thing, any professional organization with the name journalism in their name, for instance, since the FETÖ period, they tried to come up with substitutes for the professional organizations, right, with journalism in their name, but they only had a very limited number of real journalistic activities among these associations, so they weren't able to take over the profession. There are certain institutions with very ambitious names, and for instance, they are taking care of or trying to design the news perspective of the Azerbaijani media from abroad. And I still believe that there are only a limited number of real journalists among these institutions. Maybe they had some demands to the government to get a press card. For a long time, on behalf of the Turkish Journalists Association, together with former presidents, I served as a member of the committee, and we have seen how hard they tried to violate the rights together with the representatives of the union. We witnessed this, but we always able to speak up against this and stand against this, and we never ever let any unlawful behavior to take place. And at the end, both the association and the union withdrew themselves from the committee and filed a lawsuit against this. Doesn't seem sustainable. I think this is like almost the end of this. This is the last last initiative of the ruling party. And this is the last card they are trying to play, let's say. As we are heading towards the elections, as we can understand from all the remarks, there is this dark painting or that dark situation. This all indicates that on the election night, we will even have more severe problems. Maybe they will totally cut out all the internet, electricity, there will be power outages, there will be other oppressive behavior on the electricity companies and internet providers. This brings us to another issue, which is the security of elections. The opposition parties have to focus on this in a way never seen before. Because if there is a bandwidth narrow down, this can immediately ban social media access. So everybody has to do their homework well. They need to work on this. So if we have any hopes of getting back to the parliamentary system, then they need to work hard for this to avoid this restriction of bandwidth. And nobody shall think or shall feel comfortable that they will use social media anyway to express their opinions, because if we don't have access to internet, they will not be able to do this. Okay, I'll give the word to Gökhan. I know we have very limited time left. Just a few remarks. Trying to cover up the truth and have a crackdown on opposition is not the only reason for the preparation of this draft law, I believe. I think it's not only targeting the social media, but the entire truth in the country. I think they are trying to cover the truth everywhere in Turkey. We are heading towards a very, very different direction. And in order to cover up everything, they want to create an environment where they can have easier censorship. I think they're just preparing the legal grounds for this as preparation. And one final word, from the perspective of the government, this seems to be a very normal thing. They're trying to have some insurance for themselves for the future. Of course, it's normal, it's only natural that they do this, but it's important to discuss what we are going to do against this. This is something to be discussed. It's not only upon the professional associations of journalists themselves, but the society also has to have a say in this. Of course, we will have difficulty in terms of covering the news, but people will also have difficulty in terms of having access to the news. So both parties have to be organized. Okay, thank you. Veysel, do you have any final words? Yes, I'll also be very brief. This draft law cannot be taught independently of the election law or the civil society law. This is a law to conceal information, cover up information. I think people have to raise their voices more and more and louder, especially the opposition. If they want to come to the power, first of all, they need to stand against this unlawful behavior and they need to react against this. This is all I have to say. Thank you. Thank you, Veysel. Nadire Mater, one final addition. Would you like to say anything as a final word? I guess not. Okay, then Fatma Demirelli, just some final remarks. Again, you are on mute. There was a question in the beginning about the opposition acting in a stronger manner now. I'll talk about this. Yes, Ersan Pekin, writer Ersan Pekin asked this question, by the way. Yes, we see that the opposition is now, has recently been making statements to hurt and damage the government, transfer of funds to some foundations in US, and then what happened to the $128 billion question, that was also another thing. And some statements, strong statements have been made, and I'm sure during the election period, most probably we will see even stronger statements from the opposition, and then certain corruption and irregularities that might happen during the election process taken into consideration. Yes, maybe this draft law was prepared in line with those needs before the elections. Well, it seems so, but of course we don't know what really happened in the background, but this is what we can see from outside. In the text of the law, it talks about dissemination of misinformation. I see this as a threat to the society. How do you really define dissemination? Is it like retweeting? Like if you share a post, will it be considered as dissemination? And well, of course, who is going to decide what constitutes disinformation or not? Because it's very easy to intervene in the work of the judiciary nowadays. So it's going to be the political sphere that will decide on it, right? So what Gökhan has said, let me reiterate that. It's not a law against journalists or writers, anyone who knows how to read and write, who has an opinion about the society, things happening, their freedom of expression will be definitely threatened and impacted by this. That's what we have to emphasize. Yes, thank you, Fatma. Very interestingly, this misleading information or misinformation, this is a crime that is added to the Turkish Penal Code, and on the list of blocking access and catalog crimes for blocking access, this is not included in the list. Of course, the fact that we don't have it in the list today will not mean that they won't put it in the list tomorrow, not to give any ideas to everyone.
Tamam, tekrar size vereceğim.
I'll give the floor to Faruk first, and then Nadire.
Muhalefetin sesini duyurma aracı
Well,
medya aslında.
of course, it's the media that gives the opposition a voice, right? So I think the main target of the ruling party is not the opposition per se, but all the dissidents, everyone who helps them to raise their voice. So social media and independent and critical media were the two targets of this government so far, and now they're trying to impose a crackdown on these two, or increase the pressure, so to say, on this the already existing pressure. But what we need to do as journalists is to fight against this and practice our profession, journalism, even in a better way. Of course, they might take away our instruments that are available to us. They might increase the pressure on us. But in such a period of crackdown, we were able to raise some flags, and we can do it again. And not only today, but in the past in this country, during the single party period, democratic party period, we have seen a lot of pressure. Sabahattin Ali, Aziz Nesin, those people fought against this, right? So no matter how hard the conditions become, we will continue our struggles. That's what we need to do. Thank you. Okay, Nadire, you have the floor. Okay, I'll start with this question. The government doesn't want another voice. Single voice they want. Single flag, single nation, single country, and single voice. That's what they want. But we have to bear in mind that truth has this habit of coming out one day. So no matter what happens, they will not be able to conceal the truth. So we will continue our job, exercising our job. And I'll also say something on the media law. We used to say in the past, maybe I'm wrong with the numbers, but we would say regarding journalism and press, we have 52 articles violating our freedom, we would say. I don't even honestly know how many articles we have nowadays. Somebody recently asked me and I didn't know. So, without the need for the government to impose certain things upon us, we have to take the initiative as the journalists, organizations, and come up with draft laws on media ourselves. That's one thing. The second thing is, of course, we'll have to do something. The journalists, there are things that they can do, right? Of course, we have a lot to be done by the journalists, as mentioned by Faruk, but I'll add on to this. If it's about struggling or fighting against disinformation, I'll just give you a most recent example. Every time the president of the republic makes a speech, he keeps talking about the imam of the Dolmabahce Mosque. That's a total lie. It's totally a lie. And there are statements of the imam himself saying that this is a lie. So always we have to put the truth when such counter allegations are made. So this is a call I would like to make to the journalists to talk about the truth. And one final word, we will continue covering news starting from tomorrow, next week. This proposed draft law has to be analyzed in detail by everyone. That's the call I want to make to everyone here listening to us. And then there is the right to be informed by the readers. We need to also encourage the readers, provoke them more, so to speak. So this is not a discussion to be made by the journalists or the civil society alone. We have to take ownership of our freedom altogether. We have to show them that they won't be able to do all these things. And even if they enact the law, they won't be able to implement this. It all boils down to raising our voice against it. Okay, thank you, Nadire. Well, this brings us to the end of the last panel of the second day of the 13th gathering in Istanbul for freedom of expression. So I would like to thank you all one by one. And the takeaway message from this panel is that we will never be only one single voice and we will continue the struggle. Thank you and good evening.
Her defasında olduğu gibi aynı dilekle kapatalım 13. buluşmayı. Gelecek randevumuz 2024'te ama dileriz ki insanlık bugünün can yakıcı sorunlarını yarına bırakmasın ve bizim de 2 yıl sonra bir daha buluşmamıza gerek kalmasın. Olur mu dersiniz? Neden olmasın?